Well, good morning, everybody, and welcome to this third day of our hearing on the reference. And I was about to simply say to everybody, you know the ground rules, so I don't need to go over them. But I understand that there are some children from some schools here today. So if I may, just simply welcome everyone to the hearing. And I'm sure that you know that we've been asked to address a question by the Lieutenant Governor and Council, and our question that we're dealing with here in the courtroom today is whether the Greenhouse Gas Pollution Pricing Act, Canada, is unconstitutional in whole or in part. And I would just like to stress that as a Court of Appeal, when we deal with the issue with Council, we ask a lot of questions over the course of the hearing. And I have said that you should not make any assumptions from the questions we ask about what we may be thinking or what we may decide or the comments we may make. And we have had written arguments. There's books. We've got almost 5 feet of books like this that we have been provided with before the hearing by counsel who have worked very hard to put the materials together. And that is written argument. And now we're hearing oral argument. And so we've read a lot of these materials in advance, and the main purpose of the oral argument now is to have a full and frank dialogue with the council about any of the concerns that the court has. And so we are now going to hear from the council who's representing the province of British Columbia, which is intervening on the side of Canada in this reference. And we've already heard from Alberta and the interveners that are supporting Alberta. And now we've heard from Canada yesterday, and now we're going to hear from the interveners that are supporting Canada. And first is British Columbia. Welcome.
Thank you very much. Good morning, my ladies, my lords. As your ladyship pointed out, the Attorney General of British Columbia is here intervening in this reference to support the constitutionality of the Federal Greenhouse Gas Pollution Pricing Act. We say that if the dominant purpose and effect of that act is defined precisely and narrowly as black letter law requires us to do, you will find 3 things about it. First, it's about pricing. That's in the title. And there is no conduct that the conduct that this is concerned with is something anyone can engage in if they're prepared to pay the price for it. This act does not change that in any way.
May I just ask, I understand you're referring, it's about pricing, you say. You've heard the federal government yesterday advance the proposition that this should be upheld on a broader basis than simply setting minimum national standards for pricing of greenhouse gas emissions. Canada has argued that it should be upheld on the basis that it's constitutional and that the purpose is, the pith and substance here, the matter we're dealing with, is to establish minimum national standards that are integral to reducing nationwide greenhouse gas emissions. Does BC accept that characterization of the subject matter?
No. We don't think that's sufficiently precise or narrow, and we think the use of the word integral in there mixes the 2 steps in the analysis between characterization, which is an analysis of the statute, and classification, which it takes that and analyzes it in terms of the heads of power.
Your essential subject matter is similar to the determination of that from the Saskatchewan majority decision and from the Hoy decision in Ontario in concurrence. Do I understand that's your position?
That is essentially correct, yes. We think that they got it 90% right. There are nuances between those 2 positions. And I'll just briefly go into those and then and come back to it. But the Saskatchewan Court of Appeal took the position that BC advocated, which was that the pith and substance of the statute was about setting minimum standards of stringency for pricing greenhouse gas emissions. We think that is a correct statement of its primary effect. But what was left out, and this is part of the iterative process that my friend talked about, well, what Associate Chief Justice Hoy added to that was a purpose. And the purpose, she said, was to reduce greenhouse gas emissions. And I would say the only thing we add to that is that that purpose can in turn be made more precise and should be made more precise in terms of meeting Canada's national targets for reducing greenhouse gas emissions. And I'm not going to try to defend that right now, but that's our position.
So just to be clear then, your position is that the basis on which this should be upheld, that the pith and substance or subject matter, and I understand your position to be that they're one and the same, that the matter is minimum national standards, minimum national pricing stringency for pricing stringency, is that the wording you're using?
Though, if you want the exact formulation, we've said establishing minimum national pricing standards to allocate part of Canada's overall targets for greenhouse gas emissions.
Okay, I want to write this down. Establishing minimum national pricing standards for.
That's set out in bold in your factum at paragraph 4, correct?
That's correct.
To meet Canada's.
To allocate part of Canada's overall targets for greenhouse gas emissions. So
Okay, now, I know I asked this question yesterday of Canada. Is that BC's final answer?
That is our final
on what the pith and substance is? Okay, thank you.
And we say that what you then do is you take that matter, or whatever matter this court comes to as the most precise definition of its purpose and as its principal purpose and effect, you take that matter and then you determine, is that a matter that is within provincial competence, or is it a matter that is not within provincial competence because effectively it is not in the province? That's what the national concern doctrine is all about. It's about saying, because all of the province's enumerated powers are in the province, if it's not something that can, if the matter can't be characterized as being in a particular province, then it is a matter of national concern. And the Crown-Zellerbach test is a way of trying to address that in a way that is functional and preserves the balance of the Federation.
Council, you would agree, though, wouldn't you, that the challenge legislation displays features that could be classed as under Section 92 heads of power?
I do not agree that the matter of the challenge legislation.
Canada certainly did yesterday.
The way to look at it is the matter. So is the dominant purpose and effect. If you describe that as accurately and precisely and narrowly as possible, is that in relation to Section 92A? And we say it's not, because it is inherent in the matter precisely and defined that it is national in scope. I'll try to defend that proposition, but to be clear, that's our position. You look at the matter.
You're saying that the class of law that's the most important for the purpose of this analysis is the federal class of law, which is the national concern.
Well, no, because the federal national concern doctrine is what's not in the province, so they're quite linked. And so in the test, you look at, is this something that addresses extra provincial impacts?
You say that the federal class of law is the residual power, and that is the national, one example of which is national concern.
I say it, and more importantly, Justice Pigeon said it in our tab 2. He explains exactly how this works, because this answers the question that the Chief Justice asked, I think, on Monday. Can national concern override enumerated power? And the answer is no. And the explanation is tab 2. This is the Interprovincial Cooperatives case, which is a very important case, came out of one of the great environmental atrocities of our country, unfortunately, in the 1960s, when the Domtar plant in Dryden dumped mercury into the river system that caused mercury poisoning for the Grassy First Nations people, and it continued into Lake Winnipeg. And in response to that, the Manitoba legislature passed a statute, and they said, they gave anyone the right, the cause of action, to sue for damages or seek an injunction to anyone who had caused damages to a fishery in Manitoba. And they purported to make that apply to pollution that came from other provinces.
Is there any other head of power besides the national concern that in effect trumps a provincial head of power?
Well, the enumerated heads of power, the way that it works is they are carve-outs from provincial power, in effect.
They are.
The general power is what's left over after the...
It's a residual power.
It's a residual power. We call it, in fact, in the general power. And the national concern is not an exception to that. National concern is just saying, because all the provincial powers are in the province, we have to give some meaning to that. And that's national concern jurisprudence is a struggle of the courts to figure out how to give meaning to that didn't overwhelm provincial jurisdiction.
Apologize to you. Let me back you up because you were in the middle of a sentence there when you were asked a question, and I was trying to follow the sentence. You're referring to Justice Pigeon and the International Cooperatives case.
Yes.
Now, are you saying, so just so I get it, that it is not accurate in constitutional law terms to characterize the residual clause in POG as itself amounting to a form of federal jurisdiction?
No, it is certainly what he says. I'll just read it. He says, the basic principle of the division of legislative powers in Canada is that all legislative power is federal except in matters over which provincial legislatures are given exclusive authority. That's just his way of saying what the opening words of Section 91 say. Such authority is under every head, that's the provincial authority, expressly or impliedly restricted to the provincial territory. In deciding what is within a province, the courts must obviously look for guidance at decisions rendered in matters of private international law. And he goes on to talk about, because he's faced with this issue, pollution has affected the property of the people of Manitoba, but it came from Ontario and also some from Saskatchewan because of the way the river systems work. And he said, look, that's got to be federal. That's got to be under the peace, order, and good government power because there's a conflict. What Justice Ritchie, who is the swing judgment, what he says is a little more nuanced. He said, you can create a cause of action in Manitoba, but it has to be a defense of that cause of action that the activity was permitted in the other provinces. But he agrees with Justice Pigeon that the federal government can address that conflict.
But yeah, that gets us into the point of national concern you're going to get to in a moment. But I'm just trying to focus in so I make sure I clearly understand. The position of British Columbia is not that, in effect, the language of the POG clause constitutes, in a sense, itself a head of jurisdiction under Section 91. Is that right? The reason that's important is we talked about this yesterday, whether double aspect gets into this or any of that other stuff. Because if it's a head of jurisdiction of the federal government, as it is, as worded, then it becomes something that might have to be lined up against provincial jurisdiction. If it's a residual clause that only applies when there is not provincial jurisdiction, that's a totally different question, isn't it?
Well, there's two questions I think you've got in there, and one is this a residual clause? And the answer is yes, it is. And the national concern and the national emergency are the ways that it is residual. I mean, for one thing, Section 92.13 and Section 92.16 mean that if it's in the province or it's of local private nature, then it's going to be in provincial jurisdiction. But if it's not in the enumerated powers of 91.
I'm sorry to have to pin you down here because you only have a certain amount of time. Right. It's really important that we understand. If it's a residual clause only, okay, then you are not agreeing with the federal crown from yesterday on this subject of whether or not we even bring in the double aspect or any of that other stuff.
No, we absolutely do bring in double aspect. And there absolutely is a double aspect.
Oh.
How? Because the same laws can be in relation to different matters.
But that's not double aspect, that's the same aspect.
Well, okay.
What's double aspect about it?
Okay, let me take you to what the Privy Council says. So that's at tab 1. And what they say, and this is in the Canadian Temperance Federation case. This what I'm about to quote to you here is quoted in every single national concern case ever since. And they say this, in their lordships, this is at tab 1, starting where I've got the black mark. In their lordship's opinion, the true test must be found in the real subject matter of the legislation. Now, the point I'm making there is my friends from Alberta and my friends from Saskatchewan say it's not about the legislation. No, it is about the legislation. It's about the subject matter of the legislation, which is the same thing as the pith and substance, the dominant characteristic, whatever you want to call it. The other thing they say, and then they set out the classification test that gets refined and eventually is Crown Zeller back. And then they say, if this matter will fall within the competence of the Dominion Parliament as a matter affecting the peace, order, and good government of Canada, though it may in another aspect touch upon matters specifically reserved to the provincial legislatures. And there has never been a case by and that gets repeated in Johannesson, there's like 6 judgments, but they all repeat this exact passage. So they say aeronautics, that doesn't mean, and there's a case on this, it doesn't mean that you can get, when you buy liquor on a Air Canada flight in Toronto, you have to buy it from the LCBO. If you want to put to ads in the radio in Quebec, you have to comply with the Charter of the French language. If you want to dump sewage into the harbors of Victoria, you have to abide by the Provincial Environmental Management Act. So there's 2 senses of double aspect. There's the broader sense is just you have laws and they can be in relation to different matters and they can, in some sort of colloquial sense, apply the same subject matter. That has always been the case with POG as with anything else. We do not have a situation in this country where because something is on the radio, the law of contract doesn't apply.
Help us out with why you say that this act is an act that raises the double aspect doctrine as opposed to simply acting on a concurrent jurisdiction. That I think is an important point.
I think that's an important distinction. So the double aspect doctrine can be taken in 2 ways. The more precise version of the double aspect doctrine is to say that the matter is in relation to more than one head of power in different areas. And then you get into that analysis of that comes initially from Professor Lederman of how important are each of them. And if they're more or less equivalent, then that's a double aspect in the actually precise sense. That's one thing. There's a broader sense that gets used, which is just to say, well, we know that provincial laws and federal laws apply to you when you're driving a car. We know that they apply to you when you're in a boat. We know that in that sense, in that broader sense, but those may be laws in relation to different matters. The dominant purpose and effect of the statutes are not the same, but they concurrently apply to you. And there's nothing in the case law. So the point about the first type of double aspect is that, of course, for it to be a matter of national concern, by definition, it can't have been a matter of provincial concern. So the matter as defined has to be something outside provincial concern. And we say ours clearly is, because there's no way a province can establish minimum national standards across the country to get to national targets. But the province can make all kinds of laws that affect greenhouse gas emissions, including laws pricing greenhouse gas emissions, because those matters are not defined the same way. The purpose and effect of BC's carbon tax has never been judicially defined, but it clearly isn't. It's in part to raise revenue. It's in part to discourage the emission of greenhouse gases in BC. That's what it does.
Why is that not concurrent, though?
Well, I think it is concurrent in a broad sense.
And
yes,
you
absolutely.
agree that concurrency only applies if both levels of government can validly enact the law. Concurrency doesn't even come into play if there's a determination that one level of government can't pass a challenge law.
Of course, yeah.
And let me just make sure I understand, I think I do. I can't think of a law that does not fall within probably both federal and provincial powers when you start the analysis. There's a law that says you can't steal. That's a criminal law, but it has a provincial feature that deals with property and civil rights. It says you can't take someone else's property. The reason why it's criminal law is because we say the criminal feature, the federal feature, 9127, is much more important than the provincial feature. So I understand what you're saying, that there is a provincial dimension to this. There's a federal dimension, and the federal dimension is, from what I understand you're saying it trumps. As soon as we've got national concern, you meet the test, it trumps. Have I got you right?
No, I'm not saying that. I'm saying, so let's take the example of taking someone else's property. That is a crime. That is also a tort. It might, in some context, be a regulatory offense. And so you could be, if someone takes my property, I can sue them in provincial law, in the civil code in Quebec, under common law here. I might have, depending on obviously theft is a fairly straightforward one, but types of fraud might very well be Contrary to Securities Act or whatnot. So it's not about whether the act or omission or the concrete physical manifestation in the world is in relation to power. It's in whether the matter of the act is in relation. So if you take the criminal code, I don't think anyone's going to dispute that the dominant purposes and effects of the criminal code are in relation to the criminal law power. If you take the Quebec Civil Code, no one's going to dispute that the dominant purposes and effects of the Quebec Civil Code are in relation to property and civil rights in the province. They both prohibit somebody from taking somebody else's property, and they both provide remedies for if somebody does that, but they're dealt with obviously differently. So that's the point, and that's the same point with greenhouse gases. There's no trumping except under the Paramountcy doctrine, which frankly is not going to apply here very often. This law will, Attorney General for Ontario is in fact challenged. Can you tell me a law that Ontario has that will be rendered inoperable because of the Greenhouse Gas Pollution Pricing Act? And he was unable to come up with an example. There's no example in the record. So it's not, but under Paramountcy, absolutely, if there is an operational conflict or it frustrates the purpose of the federal law in that sense, which is a narrow doctrine in Canada, certainly the Attorney General of British Columbia is happy to say.
Would there not be an obvious paramountcy issue if Ontario decided that as the price increased and the minimum standards set by Canada kept going up to, let's say, $300 a ton, and it chose to price carbon at $50 a ton, would there not be an obvious conflict?
Well, at that point, the backstop would start to apply for the.
But the point is that the paramountcy comes from the operation of the federal scheme, the backstop. You're saying the backstop would apply. That means the federal legislation would be paramount over the provincial legislation.
No, the backstop would apply for the difference, but that doesn't create a paramount. There's no provincial legislation that ceases to be operating.
You would say that would be the double aspect. I'm guessing the backstop constitutes the double aspect.
In the broad sense, absolutely. Yeah, absolutely. In the broad sense of double aspect, not the more precise.
Second context that you were giving us.
Yeah, what maybe we'll call concurrency.
I guess I would understand in terms of what is meant by paramountcy. I would have thought that a legislative prescription of $50 a ton and then the federal legislative prescription of $300 a ton would be in conflict. And typically paramountcy is where the legislation is in conflict. The federal legislation is going to be given paramountcy. Is that not so?
My understanding of the way that this would work is that the backstop can apply partially. So if there is some pricing, then it would apply partially. So it would not, in that case, it would be my friend. That is my understanding.
Well,
So that's where, I guess, it comes back to the point of concurrent legislation then, and you agree that this is concurrent?
Absolutely. Absolutely concurrent in that broader sense.
But you're bearing in mind, though, that the position taken by Canada, at least at the outset, was they were under national concern, which is in the residual clause. And if there's concurrent jurisdiction with the province, that's not the residual clause, because the province already has a class of subject that pushes the residual clause aside, right?
Well, this is why I think that distinction between concurrent and the more precise sense of double aspect is important. The matter can't be the same. So the dominant purpose and effect of the legislation cannot be identical. But that doesn't stop. Just as the criminal code and the Quebec Civil Code, clearly they do not have the same pith and substance. But they both apply if somebody takes somebody else's property.
So
It's the same thing here.
But how does the residual clause apply at all? If the province has jurisdiction and one of the classes of subjects assigned to the province, then how does the residual clause apply at all?
Because what the Constitution says is that Her Majesty, bound with the advice and consent of the Senate and the House of Commons, may make laws in relation to matters
Right.
not coming within the classes of subjects
Right.
that are in exclusive provincial jurisdiction. So the matter, which we know is a term of art, and we now know what it means, it means the dominant purpose and effect. If the matter is not within the exclusive jurisdiction of the province, then, and in the national concern context, isn't because it has extra provincial effects. That's the main point.
But what you're essentially saying, I believe, is that you concede that the provinces can legislate in this area.
Absolutely.
No problem. What you're saying is because they can't legislate in another province, that makes it national in the sense of national standards. So you're saying as soon as you can put national standards in front of any area, that becomes something that the federal government is responsible.
I am not saying that. What I am saying, but I want to be very clear about this. That would be like Russell, the first case of the Privy Council. That's basically what they did. They said this was an act that let voters and municipalities decide whether they wanted to have alcohol there. And they said, well, it applies across the country, so that's good enough for us. The evolution was no, that is not enough. But again, this is at the classification stage. We want to be very precise about how we handle this, because the characterization stage, we can say this is setting minimum national standards because that's what it enables the governor and council to do. They have to take into account the adequacy of the provincial legislation. And only if they conclude it is not adequate can they list a province, and only then do the backstops apply. So that's in the characterization stage. There's no question it's setting minimum national standards. When we get to the classification stage, what we say is there's a big difference between putting a minimum national standard on a global pollutant that goes across borders than there would be on other minimum national standards. So you could imagine a federal law that put a national minimum wage. And you could characterize that however you wanted, but when you got to the classification stage, you'd say, well, wait a minute, the minimum wage the Alberta employers primarily affects Alberta workers. So that doesn't work. But when the minimum primarily affects other people in other jurisdictions, that's different. So the interprovincial cooperatives case, if the federal government said, this is how much mercury, this is how much selenium can get into an interprovincial river, that's different. It's one thing to do it say, this is the ambient. I mean, in environmental law, it's actually quite easy to make this distinction because there are examples of ambient air quality in Edmonton. That's very important. That we're not saying how important something is, but it primarily affects the people in Edmonton. And so those people get to vote in provincial elections, and so they can decide if they approve of how the provincial government has traded that off against economic considerations or whatever the other considerations are. But when it's going downstream, That's what makes it different. So it's a minimum national standard. So it's the combination of the fact that it's a minimum national standard of pricing and that is to assist in meeting Canada's overall national targets for a global pollutant.
Well,
that's the combination that makes it a national concern.
So how far can this go? Good question. When you make the point, you make a good point when you say, look, this is going across boundaries. Well, there are a lot of things that go across boundaries. Everything we do in life goes across boundaries. Emissions. Is there any reason why it could not extend to other subjects, other, quote, emissions, other basis of emitting greenhouse gases, such as smoke and the failure to perhaps mitigate those risks sufficiently?
Well, I think your ladyship is pointing out, in fact, your ladyship's question reveals the problem with an overbroad definition of the matter, because then you're dealing with something that is not before you. You don't know whether a liability for forest fires causing smoke that goes into other, you don't have that before you. So that's why the Supreme Court of Canada, and starting really with Professor Lederman's impact on this, because that's the fundamental theme of his unity and diversity article, is define the matter narrowly and precisely, and then you will best reconcile federal and provincial jurisdiction.
Mr. Morley, let me give you this.
I just should note I'm finished my time, but I obviously.
You may continue. I think this is a very important point, and I appreciate that clarification, because what you're saying is this is another reason why your formulation of what the subject matter is, and the more precise one, should be used as the basis for upholding the constitutionality, and not using that much more broadly based one, which would open up potentially a whole bunch of other room in which the federal government could then move, should it choose to do so.
Exactly. That is another case for another day.
Okay.
Same idea as the Chief Justice. Suppose we got federal legislation that says for every acre of forest land, a province has to spend $500 in forest fire fighting suppression. They rely on the national concern doctrine, because we all know, you don't have to prove this, you can take judicial notice, forest fires in Burns Lake produced a ton of smoke in Edmonton, Alberta, and probably in Saskatoon, and probably in Ontario. Can you do that under the national concern doctrine as you understand it?
I would say that you would, again, I am very reluctant there's a reason that what you do is you start with actual legislation.
Actually, the reluctance is a little misplaced, because what the questions are being put to is the idea is behavioral change, right? Mm-hmm. The government is being told, BC in this context, to change its behavior. Mm-hmm. It's a different way of changing its behavior, but it's behavioral change. I mean, if the BC government was told, stop shipping coal out of the western side of the country by this same method, that's a behavioral change that would be imposed by the federal government too, right?
Well, I think everyone would agree that a pith and substance of behavioral change would be too broad for anyone's view of the national concern doctrine. So I think we're all on board on that. That would be the end of federalism. That is why, and I'm not saying that there is no conceivable federal legislation that might have impact on forest fires and on provinces' responsibilities. I'm just saying that that's not what's before you. We don't have the record on that.
Actually, sorry, Kerry.
And that's why Professor Lederman said way back, and the courts listened, define it narrowly, start with the purpose and effects of the actual statute before you. A distinction between pricing and regulation, that's a distinction that common law long made. There's a big difference between specific performance and damages. That's the medieval court. The courts of equity did one thing, the common law courts did another. It's a big difference in terms of the impact on provincial powers. So stay with what is before you. You've got a minimum standards of pricing. You have to decide whether that's a
But the pricing is for what
we're going to do that. We're going to answer that in this reference. And Professor Lederman did not like references for some of the reasons you mentioned. But one of the things that we're always concerned about is, what is the impact of what we do? And if we say the national concern doctrine is going to apply here, that's a head of power, then we want to know what else that means. And I think the example I just gave you, if the national concern doctrine applies here, it's going to apply there. Well, are we happy with that? We got to have that in our minds.
I think any time a court makes a decision, obviously it could be a precedent for a future decision. But that's as far as you need to go, because what you need to say is setting a minimum level of pricing. And we've explained why we think it is, because there's what the economists call a collective action problem. It would be great if somebody else deals with this. Everybody's in favor of that. Nobody wants to pay the price. So if we're going to get to any kind of national targets, it's going to cost somebody something. And so there's got to be a way of allocating that. And the way that the Parliament has decided is the fairest and most efficient way to allocate part, not all, of the burden is to say, let's have a minimum national standard of pricing. And the evidence before you is that has
It's not, not maybe insignificant, but minimal. Would this, given the basis on which Canada has argued that the legislation should be upheld, that is establishing minimum national standards that are integral to reducing nationwide greenhouse emissions, gas emissions, would it allow Canada then to set minimum standards for emissions on both existing and new projects? In other words, not pricing. I'm not talking about pricing, because your formulation is it's pricing. Their formulation or proposal is it's much broader, and it's minimum national standards integral to reducing greenhouse gas emissions. So does that then raise the prospect of Canada stating that no new projects will be approved if there is not a net neutral result? In other words, if the emissions are not neutral, captured by way of storage or whatever, could they then do it on that basis?
Well, this is why we're here, is so that the answer this court gives does not answer that question. My friends on this side have defined things broadly because they want you to say, if this happens, it'll be the end of federalism. And my friends from Canada, they want a little bit of flexibility for the next case. And what I'm asking you to do is not give them that flexibility. I'm asking you to decide this case on this statute and its purpose and its effect.
Can I get back in now? No, I guess not. No, the point is, though, that the real difficulty is, though, is there's a syllogism in this statute. The syllogism is that you achieve reduction of greenhouse gas emissions by behavioral change. Pricing standards of a national level or not have no relevance unless you're achieving behavioral change. Now, I heard you to say that behavioral change as a basis of national concern would be the end of federalism. I agree with you. Now, the problem is, though, is that this act requires the syllogism to be completed. You can't leave a space out of it. The behavioral change is essential to the relevance of pricing. So you can't just say, oh no, it's national standards of pricing. To what end? Mm-hmm. To the end of changing behavior. So therefore, you can't say that we can duck that, we can kick the can down the road. That's just not logical, is it?
Well, I think you got to be specific about the effects of this statute that are specific to this statute and the purposes of this statute. And that, of course, will give you a broader power than just the exact words of the existing statute, because you could amend it and still have the same dominant purpose and effect. But you're not deciding it, you know, and I obviously would say that no province could countenance the idea that behavioral change as such. But I don't think there's a problem in saying that this act aims at behavioral change, since the criminal code aims at behavioral change.
Well, that's what gives it the national concern.
The ICBC.
You said a moment ago, fairly enough, you said this. You said the characterization stage puts this into the national concern basket, in effect, because the provincial approach is, quote, your word, inadequate, unquote. And if you look at the GIC's order, that's what they're talking about. Inappropriate, inadequate, which means that what justifies the national concern here is the inadequacy of the provincial approach to what? To deterrence, to behavioral change. If it falls short of enough to make a behavioral change, then the legislation, the federal government's doorway is open and in it goes. That's what it is. That's what this law says. It doesn't say something else. And that's why I agree with you at the beginning. You made that comment about, well, it's very important to be precise. It's also important to be accurate.
Well, I think what my submission is this is accurate. And the point I would make is this, and I do want to just, because we need to talk about the effects on people. And ultimately, this is what the Constitution is ultimately about. And we have discussed, and it's very important to the economy and identity of this province is the oil and gas industry, and the ability to manage and conserve and develop that industry is set out in Section 92A1.
And may I also say it's actually very important to Canada too, because let's also talk about another elephant in the room, which is that oil and gas industry is extremely important to Canada's economic base, because Alberta's ability to be the primary funder of equalization payments is contingent upon its ability to continue to be able to have an economic train that is generating wealth that benefits every province in Canada.
But what I wanted to say is that there is also a industry that has been fundamental to the identity economy of British Columbia that is also protected by Section 92A1, and that is the forest industry. And the forest industry in British Columbia is currently going through a crisis. And part of the reason for that crisis was the epidemic of the mountain pine beetle in the 1990s and early part of the century. And the reason that that happened was climate change. What controlled the spread of the beetle from time immemorial were cold winters. And when the winters stopped being so cold, the beetle spread, and more than half of British Columbia's interior merchantable timber was destroyed.
Council,
The significance of this is this for the Constitution. It's not just rhetoric, because the significance for the Constitution is we have the jurisdictional power to manage and conserve and develop that resource, but we do not have the jurisdictional power to protect that resource from things that come from outside, or to protect our other resources, or to protect the health and well-being of our citizens, unless what we do in terms of price stringency is matched elsewhere.
Mr. Moore, I was listening to the conversation, the dialogue between yourself and Justice Watson. Does it, with respect to behavioral change, does it do any damage to your characterization, which is establishing minimal national pricing standards to allocate part of Canada's overall targets for greenhouse gas emissions reduction, if you added, as suggested by Justice Watson, a preliminary clause, something like to affect behavioral change throughout Canada by establishing minimum national pricing standards to allocate part of Canada's overall targets for greenhouse gas emissions reduction. Does that do any damage to your characterization, or in fact, does it make it further precise, as suggested perhaps by Justice Watson?
If it's just limiting it, then it's not a problem. Obviously, there's a trade-off between precision and verbosity, which we've tried to manage, and maybe one can judge that. But there's no problem with saying it's part of behavioral change. My problem would be to say this is about behavioral change and leave it at that, because obviously we can't possibly.
But that's not what I've suggested.
No, and so, my lord,
You're doing the same thing as your colleague did yesterday. You're not entirely sure you want to take that.
Look, at the end, we have said what our final position is. We were told we had to, and we did. Our final position isn't what matters. Your final position is what matters, and what matters is characterizing this act as precisely as possible, and behavioral change is part of it. There's no question about it. It's just that you have to also say, how is it changing behavior? It's changing behavior by pricing, not by banning. That's a big difference. And it's not changing it by saying this is how you have to price. It's saying it by you need to meet a certain level of stringency. If you do, you can have a cap and trade system, you can have an output-based system, you can have just a levy, you can do what you want. But if you don't, then there has to be something, so there's a backstop. That's.
Let me, sorry, I have a slightly different question, but it's related to this. And you run out of your time. So, but I'm very interested in your opinion on this. The suggestion seems to be made by Canada that, in fact, the provinces can't do this on a national level. In other words, the provinces. It's a circle, of course. It's national because it's national. That's kind of how that works out. And there's flaws in that reasoning too. But setting that aside, why are we assuming that it is impossible for all of the provinces to agree on exactly what you just said?
Okay.
Why can't they do that together without the federal government's interference? Why not?
Well, the standard isn't whether it's impossible.
No, it's incapable. It is impossible.
This is exactly like systemic risk. This is the case that is the closest to this. In 2008, there was a global financial crisis. We avoided some of the worst of the financial parts of it, but we had asset-backed paper, big problem. What the Supreme Court of Canada said in the 2011 reference, that's the last tab here, is it said, and I've kind of just reworded this in the outline to say with greenhouse gases. But the point is not that the provinces are constitutionally or practically unable to adopt legislation aimed at greenhouse gas emissions within the province or systemic risk within the province. The point is simply that because provinces could always withdraw from an interprovincial scheme, there is no assurance that they could effectively address issues of systemic risk or national greenhouse gas emission targets on a sustained basis. The point that the Supreme Court of Canada was making—
It's anticipatory jurisdiction.
They made the point that because legislatures are sovereign, because there's elections, interprovincial agreements are good, they're the better way to go, but they are not enough to address something of the kind of importance of a financial crisis. And they're also not, and this is similar in magnitude, if not greater in magnitude, to another financial crisis like in 2008. So the point is that, and the experience is exactly this. This is exactly what happened. We did have a deal, and then we had elections, which is what we're supposed to have. And that's absolutely fine for if the province is making its decisions about what it does for itself. That's who should make it. It should be the people who are accountable to the electorate of that province. And if that electorate doesn't like it, they can pick another group later.
So the national concern is, let me just pick this up. The national concern is that interprovincial agreements aren't good enough.
Interprovincial agreements won't provide a sustained—
they may be good enough today or even next year, but they won't be good enough in 2 years, so therefore they're no good enough.
That's what the Supreme Court of Canada said, yes. And in terms of systemic risk, we didn't actually have a breakdown of an interprovincial agreement. In terms of greenhouse gases, pricing, that is exactly what we had. That exactly happened. The scenario they unfolded on paragraph 120 of the securities reference is precisely what is in the record. And that would be fine to the extent that the people of Ontario or Alberta or Saskatchewan or British Columbia are making decisions for British Columbia or Saskatchewan or Alberta, Ontario, of course. But if they're making decisions that affect everyone, then there's only one legislature in which everyone is represented, and that's Parliament. That's why there is a federal government. That is why it's left with matters of national concern.
Well, ordinarily, though, in the list of items under Section 92, we have something called the Uniform Law Conference. Have you heard of it?
Yes, of course.
And there's a lot of laws in this country which are uniform across the country under those topics, are there not? Did the federal government have to butt in on those?
Not at all. No, and uniformity is not a basis. That is also very clear in securities. Uniformity is a nice thing to have, but it's up to the provinces to decide how uniform they want to be. It's just about if it's just about the benefits of uniformity, that is not a basis for national concern. The basis here is there's a collective action problem that everybody's affected by what everybody else does. What matters is the total amount of emissions. And if the more that is, one more ton in one place is one less ton that could be in any other place, consistent with whatever climate stabilization target we seek. That is the reality. There is a finite budget.
Okay, but some are affected more than others because we've talked about this, and I haven't asked you about the fact of different ratings for different sectors or different products. For example, exemptions is propane exempt, for example, for heating of homes in certain provinces.
Sorry, I think the point I would make about that is that's why the mechanism of saying there has to be a judgment of stringency, there's a discretion to that because you've got multiple types that you can have, but it's reviewable for reasonableness and fairness in the federal court. It is a legal determination the Governor Council has to make. So basically my point is about that is those choices within a certain envelope of stringency are for the provinces to make, unless they refuse to make them. Well, that is how it works.
I'm not sure what claim Alberta would have over the fact that on your theory of the fact that the legislation was valid nationally, to be able to complain about the fact that, for example, propane was not being put on, it was exempt for certain purposes in another part of the country. So
No, they
it's
don't-
exempt for heating homes or for certain uses in one province, but the primary method for heating homes in another is natural gas, and one is covered and one is not. Is that appropriate? Is that something we should be looking at?
No, I don't think there is a legit, it's just like BC has no legitimate claim to say, Quebec, we really think you should have used this system because the economists like it better. That's not up to, we have no legitimate claim if you're meeting a level of stringency that has to be set by the federal government because no one else can set it. We have no legitimate claim as to how you do it. If you want to exempt a particular industry, as long as you meet an overall coverage of about 80%, you get to decide that. If you want to do it one way or the other, you get to decide that. And that's crucial to the constitutionality of this act, because it's, Alberta wouldn't have a legitimate claim about the propane as long as that other jurisdiction was in overall meeting an adequate level of stringency. I'm well over my time, but I will.
No, I appreciate it very much. I thought it very interesting.
I just want to sum up. May I sum up your position this way? And perhaps this is being unduly simplistic, but what I hear you saying is the provinces are asking for too much. The federal government is asking for too much, but you've pretty much got it just right.
That is exactly correct.
Okay. We'll take the morning break at this time. Thank you. Good morning.
Good morning, Chief Justice, Justices.
And just to confirm, you're here on behalf of the
The David Suzuki Foundation.
Foundation.
Yes, I'm Joshua Ginsberg. This is my colleague, Anna McIntosh. Justices, yesterday you heard that climate change is a global threat and an existential crisis for Canada. I submit that we must begin our analysis of Parliament's signature response to that crisis clear-eyed about the truth of that crisis, and that is that our way of life, and indeed our lives, are at stake here when it comes to climate change. It is truly a national emergency. Now, the crisis of climate change has many dimensions, but the acute emergency facing Canada and its governments is this shrinking window of time that we have left to save ourselves from the most devastating impacts, the impacts that will be locked in if we don't act now in the short term. And the evidence before this court is that Canada only has a very short time to avoid those effects, 10 years. That is the timeline that we're dealing with to act. And Parliament perceived that deadline to avoid the worst impacts of climate change as an emergency and acted within its constitutional authority to address that emergency. And its chosen means of doing so was the Greenhouse Gas Pollution Pricing Act, which aims, in the short term, to put Canada on a path to the emissions reductions that are necessary to stabilize the climate. Now, my submissions this morning will roughly follow the outline that I have at tab 1 of my condensed book, and it consists of 3 points. The first is that the GGPPA is Parliament's rational response to this climate emergency. The second is that the act that responds to it is inherently of a temporary character. And then third, that the POG emergency power is neither truly extreme nor drastic, as Alberta and to some extent Ontario characterize it. Rather, it is a restrained and limited intervention to accomplish a focused and short-term goal which preserves the balance of federalism, which does not alter the fundamental structure of the division of powers. So to the first point, that there was and is a rational basis for the GGPPA as emergency legislation. Chief Justice Laskin formulated the test in anti-inflation, which I have at tab 2 of the condensed book at page 3, it's page 420 of anti-inflation. He formulated this test as does the extrinsic evidence put before the court and other matters of which the court can take judicial notice without extrinsic material to back it up, show that there was a rational basis for the act as a crisis measure. And here, no one is actually contesting that climate change constitutes a crisis in a broad sense for Canada. And in fact, the Saskatchewan Court of Appeal, in the reference case on the same legislation, said that climate change is doubtless an emergency in the sense that it presents a genuine threat to Canada. That was at paragraph 202 of that decision. Our factum at paragraph 6 to 15 canvasses in some detail the statements of MPs and ministers regarding the climate emergency and the Greenhouse Gas Pollution Pricing Act as a response to it. And I would only note there that yes, it is true the term emergency was not used extensively, is not used in the Act at all, but as Ontario conceded in its submissions, that is not required. The only thing that is required is that Parliament treated the situation as truly a crisis. And if there's any question that that is true, I've included in the condensed book at tab 3 the language of the preamble, which, Justice Watson, as you noted, is the first place that we look to discern intent here. And the second 2 clauses tell the story. Whereas recent anthropogenic emissions of greenhouse gas emissions are at the highest level in history and present an unprecedented risk to the environment, including its biological diversity, to human health, safety, and economic prosperity. And whereas impacts of climate change, such as coastal erosion, thawing permafrost, increases in heat wave, droughts, flooding, and related risks to critical infrastructures and food security are already being felt throughout Canada and are impacting Canadians, in particular, Indigenous peoples of Canada, low-income citizens, and northern coastal and remote communities. These are crisis terms. And at tab 4, we have the statements of Minister McKenna, who at the time was the responsible minister, in the introduction of the Act. And she said here, just above, under where it says translation here on page 10 of the condensed book, that Canadians understand climate change is real. They know that governments at home around the world must urgently address the challenge. And then down the page, she talks about some of the disasters that we're already experiencing, including here in Alberta. One of the hardest calls I've ever had to make was to a rancher in Alberta's interior. Her family ranch was destroyed by intense wildfires that spread through BC and Alberta. Today, as a result of climate change, these wildfires are raging longer and harsher than ever before. It's an emergency. It couldn't be clearer. And later in a debate, an emergency debate on the crisis, the minister said, the emergency we are talking about now was an emergency 10 years ago. She used the word. It has been an emergency, it is an emergency, and Parliament is now acting. And the last point on this is at tab 5 of my condensed book. We have the statement of the sponsor of the bill, MP Lightbound, who directly linked the Canada's 2030 targets to the GGPPA. He said that the GGPPA puts Canada on course to meet that 2030 target, that short-term immediate target that we absolutely must hit, or future action will become less meaningful. So on its face, I don't think there really is any question that this is emergency legislation. It responds to the emergency of climate change by trying to get emissions down between now and 2030, and I call that period the acute emergency, because it's that near-term crisis, and renders the GGPA temporary, and that's what I'll turn to now, temporary nature of this law. So Alberta says, first of all, that, look, this act isn't temporary because climate change is, quote, not a temporary problem. But that's contrary to the evidence before this court, which is that we are actually required to take sufficient action before 2030 if we want to avoid those worst impacts. We have on our hands, justices, the temporary problem of ensuring that our planet does not cross dangerous climatic tipping points that will threaten life in many parts of the world, including and especially here in Canada.
Council, isn't that a continuing problem? We are always going to be emitting some greenhouse gases. We are at a certain threshold, and if we pull back from that threshold today, isn't that threshold always there looming ahead of us, so that we have to continuously attempt to pull back, probably forever?
So, Justice, you're right in the sense that there will always be a need to be cognizant of emissions, but the evidence before the court and what animates, I submit, this particular legislation is this short-term deadline that unless we do a lot of that you're describing by 2030, our future actions aren't even going to matter, right? We have to get that right in 10 years. And I'll point you to, it's tab 10 of the condensed book. This is the IPCC special report, which is the focus of this emergency debate before Parliament. And this is the affidavit of Mr. Moffat, who summarizes it nicely. He says, global net caused human emissions of CO2 would need to fall by about 45% from 2010 levels by 2030 and reach net zero around 2050. So it's that first target, that 2030 target, which is replete in the legislation and in the debates that we absolutely have to meet, if the 2050 reductions are going to be effective. The Act is about getting us to where we need to be to put us on that course.
I think the question that you're being asked is that if that somehow failed, is there a possibility, therefore, that the continued need would be there past 2030, especially given the fact that Canada can only control what Canada does, we as a country. In other words, there are other countries in the world too, and if they're not meeting standards they've set or standards we think they should have set, isn't there the very real possibility of a continuing emergency past 2030?
You're absolutely right, Justice. The emergency is a global one in that it is a collective action problem. And that is why the Act tries to promote collective action in Canada. We can only do our part, right? we can't do anything more than what is our fair share under the Global Pact. But if we don't meet it, and others don't, if we don't collectively meet it, then the world has no chance.
But
So-
if we met it, because you say this is temporary and we could do this, we must do it, we've got to get to these levels by 2030, but let's assume that we did do that, but the other parts of the world, other countries did not do it, would it not therefore continue to fall within the purview of the theory you're espousing, that the emergency would then continue and that we might in fact have to then do more to pick up the slack of what others are doing less on?
So constitutionally speaking, because this act is aimed at 2030 and has been explicit that its purpose is getting to those emissions, I think any province would have a good argument if we've achieved that, if we've gotten to where we need to be, that in fact the emergency as Parliament perceived it, which is Canada's need to get to that place, has abated. Now, whether or not there are other actions that could be taken elsewhere in the world or in Canada that would continue to mitigate the crisis is a different question. But so far as this act goes, I say it's about 2030 for Canada. And that is a very important control and actually makes my submission much more constrained even than BC's, which you said was the tightest so far. We say it's all about the act. I'll get into this later, but it's important to remember there's no subject matter jurisdiction here. We don't say that the emergency doctrine conveys, and it's clear that it doesn't, any continuing jurisdiction on Parliament to make laws for any particular matter, because we don't define the matter. What matters is the act itself. And that act was passed in light of these dire warnings from the scientific community that it's essential to reduce GHG emissions and do that expediently. I've already taken you to tab 10. There are also very clear indicia that the act was passed with the intent of achieving those short-term goals. I'll take you again to another part of the preamble that makes that quite clear, tab 3. Second down the page. Whereas the Government of Canada is committed to achieving Canada's nationally determined contribution and increasing it over time under the Paris Agreement by taking comprehensive action to reduce emissions, et cetera, et cetera. So that NDC is the 2030 target. Now, Ontario makes something of this phrase, and increasing over time. But I think we should be clear about this. That has to be read in light of the ambition to meet the NDC, which is a 2030 goal. The ambition of that goal can be increased. And indeed, as we saw in the recent mandate letter to the Minister of Environment, indeed, Canada wants to increase that ambition. We want to do more by 2030. We want to bring our target in line with the one I just read to you, which is the IPCC goal, 45% below 2010 levels by 2030. So we can do that, but that does not mean that the mechanism extends beyond 2030, as Ontario seems to suggest. There's also, at tab 11, the Pan-Canadian Framework, which under this large bold heading, Pathway to Meeting Canada's 2010 Target, sets out several measures and then says in a note, reductions from carbon pricing are built in to different elements depending on, reductions from carbon pricing are built into different elements depending on whether they are implemented, announced, or included in the Pan-Canadian Framework. So carbon pricing is the sine qua non for all other efforts aimed at 2030. And the other point is that Parliament actually declared a national climate emergency, which it said requires as a response that Canada commit to meeting its national emissions target under Paris. It's 2030. It's the short-term acute emergency. There are also key provisions in the Act and in the framework requiring ongoing review and frequent reporting, which are indicators of Parliament's intention for close oversight and the recognition to actually continually revisit the circumstances giving rise to the Act and give Parliament an opportunity to say, emergency over. It's enough. It'll include an expert assessment of stringency, effectiveness, etc. It'll give Parliament the tools it needs to make that decision. And that's why Professor Hogg, was a bit skeptical of even the need to speak of temporariness, because he called it, and that's again the same tab I took you to, tab, pardon me. Tab 9. Thank you. He called it a primarily formal limitation because an ostensibly temporary measure can always be continued and enforced by Parliament, whereas an ostensibly permanent measure can be repealed. So the question is, if the aim of the legislation is time limited, as we say this absolutely is, whether there's a formal limitation is pretty much irrelevant, because Parliament will do what it's going to do. But here they have the tools to make that decision when it is appropriate to do so. And in addition, the evidence before this court is that, in fact, the true effectiveness of GHG emissions pricing is a tool to create short-term behavioral change. The idea is to get on track to meeting the goals, and then it becomes less necessary. So this is at tab 14 of my book. It's an excerpt from the High-Level Commission on Carbon Price, which is chaired by Joseph Stiglitz, the Nobel laureate in economics, and Nicholas Stern, the former chief economist of the World Bank. And they say that high carbon prices today, as we have now and increasing to 2022 and in place until 2030, they say that those high carbon prices are needed to drive changes. And if we have those prices now, we may not in fact need any future increases. So what we do now means we won't need the pain, if you want to describe it that way, later on. We have to take our medicine now, and later we're cured. That's the point of carbon pricing.
We're not going to be cured if other people are not curing things themselves as well, though. I mean, we can't be naive. And all of you know well about this, that the carbon leakage issue doesn't just apply to Canada as between provinces, it also applies internationally. So part of this is the cooperative effort internationally that's required, and I know you certainly recognize that.
You're quite right, Chief Justice, and that's why the Act deals with the carbon leakage through setting special rules for industry-exposed industries. I see my time limit is up. So by way of conclusion, let me just say two things. Subject to any questions. First is that it is very well established in the case law that the emergency legislation is only valid for as long as the emergency persists. And I'd just like you to have reference to tab 18 of our book, which is that statement by Justice Laskin in Anti-Inflation, and tab 15, which is a statement of Lord Haldane in Fort Francis. And what it means is that this court and other courts in Canada will maintain jurisdiction over the GGPPA, such that a decision of this court that the Act is validly passed pursuant to emergency is not res judicata in the future. It will be open to Alberta or any other province to return to court and say this emergency is abated and it's no longer constitutional. Chief Justice, yesterday you said, is it really open to this court to revisit the constitutionality of this Act at a later time? We're making a decision today. And under the emergency branch, I say absolutely yes.
But we were talking yesterday about national concern doctrine.
Correct.
I mean, the theory that was being put, as you're aware, was that we could uphold it today, and if it turned out the effects were worse than thought, someone could come back later and argue it's unconstitutional. And we asked for authority for that proposition, and I don't believe there is any.
And I haven't looked, but I would be inclined to think that that is correct. And I'm drawing the distinction between the national concern in that respect and emergency, where it's very clear that it's not res judicata at all.
Could I ask you, sorry, I'll let you finish your points, and then I do have a couple of, one thing I would like to ask you.
Please ask me now, if it's on your mind.
I wanted to know whether if this were upheld under the national emergency aspect of peace, order, and good government, would that then allow the federal government not only to price carbon dioxide emissions, but allow Canada, the federal government, to basically prescribe that there could be, for example, no emissions on any new plants that were begun, or that they had to reach a net neutral position, a net position of no no emissions by a certain number of years. In other words, does it give the government the ability then to go beyond under national emergency simply pricing of carbon? Because I believe it was Ontario that made the point that this doesn't prevent pollution per se, it puts a price on pollution. Would you say that under the national emergency power, that would then permit the government under this act to actually then restrict, limit, prevent development of new projects unless it could be said that there was no further contribution to Canada's carbon dioxide emissions?
Well, I think if I understand your question correctly, Chief Justice, that the answer is no, because the Act doesn't provide for any such jurisdiction to do so, that I'm aware of. And under the emergency branch, Parliament is very strictly limited to the terms or rather, the executive is limited to the terms that Parliament has authorized to address the emergency. And if that isn't included, then the answer is unequivocally no.
If it's establishing minimum national standards integral to reducing nationwide greenhouse gas emissions, why could the federal government not prescribe that any new projects had to meet certain minimum standards in terms of emissions from the new plant? That's what I'm asking.
I think it's an important distinction because what you've described is a subject matter that we would assign to a new matter under national concern. And we don't have that under national emergency. We have no jurisdiction, no independent jurisdiction to do any such thing. Under national emergency, we have only what the Act authorizes and prescribes and nothing further.
But Canada has already acknowledged that the Act could expand categories of sectors, it could reduce it, it could increase carbon pricing to whatever level it wanted. Is there any reason why it couldn't set a price for carbon emissions for new plants, minimum standards for new plants, a pricing level that was essentially cost prohibitive, or certainly prohibitive to the point where it militated against the likelihood or financing of new developments?
Well, as I think my friend from Canada said yesterday, the matter of the actual price is somewhat malleable. There is jurisdiction to do that, but she also said that we have to be reasonable about what Parliament will do and won't do, and there's no indication on the record before the court that the carbon price will be raised anywhere beyond $50 by 2022, and certainly not to any level that would cripple the economy. It's just not any suggestion anywhere.
That's not the issue. The issue isn't whether somebody currently has in their head an idea that it's going to be priced at a level that would be prohibitive or would militate against development in a meaningful way. The question is, once the jurisdiction is conveyed on this basis, is there anything to prevent that happening from the point of view of legislation?
No. And so, we can search and see whether or not that exists, but the point is that there is clear control through Parliament's clear language. We can't go beyond it. So I guess I'm saying I'm not sure if the jurisdiction to do exactly that exists in the Act. And if it does, yes. If not, no.
Okay, so I understand
think
what
that's the
you're
best I
saying
can
is you prefer to look at the Act as a whole as it exists right now and say, look, this is absolutely justified under national emergency. That is where we are. It's imperative that we reach these levels by 2030, and that's as far as this legislation goes.
You have it. Thank you.
Thank you so much. Does the panel have any questions that you wish to ask Mr. Ginsburg? Thank you so much for your assistance.
Thank you, Chief Justice and Justice.
Thank you. Good morning, Ms. Dean.
Good morning, Chief Justice, Justices. And it can also transform that problem into one that can be addressed by the criminal law. So it's important to distinguish briefly the difference between public health and healthcare in order to conceptualize the divide of legislative powers in regards to health. Public health is the science and practice of improving the health and safety of whole populations, while healthcare, in contrast, works on an individual level and is concerned with the provision of health and medical services. There's no controversy here that climate change will be incredibly damaging to human health and that the public effects will be pan-Canadian and global in nature. The scope of the problem has constitutional dimensions. As the Schneider decision, which is at tab 5 of the condensed book, tells us at page 142, the nature and scope of the public health problem must be considered in determining whether a matter is of national concern. The national scope of the human health threat of the climate crisis is recognized in the Act's preamble. In the second paragraph, it says, whereas recent anthropogenic emissions of greenhouse gases are at the highest level in history and present an unprecedented risk to the environment, including its biological diversity, human health and safety, and to economic prosperity. And at the third to last paragraph, it says, whereas the absence of greenhouse gas emissions pricing in some provinces and a lack of stringency in some provincial greenhouse gas emissions pricing systems could contribute to significant deleterious effects on the environment, including its biological diversity, on human health and safety, on economic prosperity. And this is, of course, supported by voluminous evidence in the record from CPHA and from Canada about the significant nationwide human health impacts of climate change. CPHA says that given the scope of the problem, Parliament has not only the ability, but also the responsibility to protect Canadians' public health from the national threat of greenhouse gas emissions. From the earliest division of powers jurisprudence, it has been recognized that Canada and the provinces both have jurisdiction over matters concerning public health and safety. And that's from Russell v. the Queen, where the Privy Council upheld the Temperance Act based on the POG. While provinces have a role in the day-to-day management and provision of health services, Parliament that decision.
Help me just a bit with the Syncrude case. That was the Federal Court of Appeal decision that upheld a determination that you could tell a business entirely located in Alberta that 2% of the fuel that they used only on their site had to have a biodiesel component. Is that the one?
That's correct, yes.
And the court used criminal law power to uphold that?
Yes, it did. And at issue there was whether there was a valid criminal law purpose because it had market effects. I'll get to that in a minute. Really, I don't think there's any controversy here that public health protection is a valid criminal law purpose. The issue here, as my friends from Ontario argued on Monday, is whether the Act contains prohibitions and penalties. CPHA says that it does. The GGPPA, like SEPA and the regulations in Syncrude, behaves like a criminal law. It prohibits the unpriced emission of carbon and contains registration and reporting requirements. If you emit carbon without paying, you commit a crime. These prohibitions are backed by penalties. The GGPPA creates offenses for non-compliance, and I would refer the court to sections 37 sub 1, 131, 132, 133, 135, 232, and 233 of the Act, where the prohibitions, penalties, and offenses are set out. And I also understood my friend, Mr. Gull, to concede in his submissions on Monday that the purpose of the law is the incremental prohibition of emissions. The law here is similar to the regulations in Syncrude, which required 2% of diesel fuel to be renewable fuel. If diesel fuel fails to meet this standard, it cannot be sold, produced, or imported into Canada. So here, for example, a retailer in a jurisdiction where the federal backstop is applied cannot sell fuel without paying a charge. If they fail to do so, it is an offense with penalties attached. To hopefully assist this court with this submission, we have provided at paragraph 39 of our factum a list of the similarities between this legislation and SEPA. This is particularly so where outright prohibition is not practicable, as in the case with tobacco, as in the case with guns, and with greenhouse gas emissions. Parliament must be allowed to be innovative in seeking alternatives to outright prohibition, and that's from RJR McDonald at paragraph 39. That is why the criminal law power is wide and flexible and should be broadly construed by the courts. CPHA says that this kind of innovation is exactly what Parliament has engaged in here in order to address the pressing health threat of greenhouse gas emissions. Syncrude is an example of a flexible approach to the criminal law power. Syncrude claimed there that the regulations were not actually criminal because it was an economic measure that was aimed at creating a domestic market for renewable fuels. The court disagreed and held that the dominant purpose of the regulations was to protect the environment. The creation of demand for renewable fuels was simply a necessary and integral part of the strategy to reduce greenhouse gas emissions.
What did the record in the Syncrude case disclose as to how requiring Syncrude to put 2% of bioproducts into its diesel? Was there anything said there that would answer that question? Do you recall?
I'm not sure I understand your question, Justice.
As I understand it, it's been a while since I've looked at it. That was a 2016 decision. Syncrude produces diesel on site from its own processes and uses that to power all of the equipment that is there. To put biodiesel together, you would require massive transportation from distances of the additive to do that, which would create a huge amount of greenhouse gas emissions. Was there any discussion of that? I'm just trying to recall.
Not that I recall, no. The discussion was that This would create a market for renewable fuels, which would in turn reduce greenhouse gas emissions. And what we see in the Syncrude decision is that the criminal law can be used to support market-based emissions, trading schemes, or other pricing mechanisms. Further, legislation that is indirect and aimed at behavioral modification is still valid criminal law. As the Federal Court of Appeals said in Syncrude decision, quote, all criminal law seeks to deter or modify behavior, and it remains a valid use of the power if Parliament foresees behavioral responses either in persons or in the economy, end quote, and that's at paragraph 69. Rather, a 2% renewable requirement was put in place. Here, what is prohibited is emitting GHGs without paying a charge. And before I close, I want to address the comments of my friend, counsel for Saskatchewan, and those of Mr. Justice Wakeling on Monday about not being able to add a prohibition and a penalty to a statute and have a criminal law. And I believe your lordship mentioned the Board of Commerce case where the issue there was clothing retailers being prohibited from charging unfair profits on sales.
I was also thinking about the margarine reference case.
Right, so the margarine reference case sort of updated that law, right, in the Board of Commerce decision and said, no, you're right, it's not okay to just have a prohibition and a penalty. There must also be a valid criminal law purpose. And that's also in Hydro-Quebec. It also speaks to that issue at paragraph 121, where it says, quote, the criminal law power does not permit Parliament simply by legislating in the proper form to colorably invade areas of exclusive provincial legislative competence. To determine whether such an attempt is being made, it is of course appropriate to inquire into Parliament's purpose in enacting the legislation, end quote. Here it's undisputed that the purpose of the act is to protect health and the environment, and these are public purposes that will sustain a law made pursuant to the criminal law power. In closing, unless there are any other questions on the criminal law power, the climate crisis is a social, environmental, and economic justice issue. The public health effects of climate change will be experienced most acutely by the world's poor, by Indigenous peoples, including the Indigenous peoples of Canada, and by those who did very little to contribute to the global climate crisis. Canada's imperative as a wealthy nation that is one of the world's largest contributors to greenhouse gas emissions is to meet its international climate change obligations, including by taking the necessary steps to significantly reduce those emissions. It cannot be that Canada does not have a role in the regulation of greenhouse gas emissions, given the urgency of the public health issues at play. CPHA says that Canada can do this both under the peace, order, and good government power and under the criminal law power. Those are my submissions. I thank the court for its time.
I do have a question.
Oh, yes.
In this case, the Canadian Environmental Protection Act responsibility for pollutions to prevent, control, correct air pollution under its laws, but then the federal government had a right to backstop that if the provincial government. Can you tell us a little bit more about that and why Hydro-Quebec came to that conclusion that the backstop provision was constitutionally acceptable there?
Well, I think in our factum, we are making the point that that there are federal backstops in CEPA and in the GGPPA. I'm not sure that we cite that decision for that proposition, or the proposition that you're putting forward. So I'm not sure I'm really prepared to answer that question.
All I'm saying is, did the Supreme Court of Canada in Hydro-Quebec talk about the constitutionality of a backstop under the CEPA?
I believe that it did, but I cannot recall with any specificity as to what it says.
We'll check it then, thanks.
Thank you.
Any questions of comments? And thank you very much for your very concise and helpful comments.
Thank you.
Thank you. All right. Thank you very much, and welcome to the intervener Climate Justice, Saskatoon et al., and that's Mr. Stockdale and Ms. Yee. Morning.
Good afternoon, Chief Justice, Justices. My name is Jonathan Stockdale. I'm present with my colleague, Ms. Yee. We represent Climate Justice Saskatoon, the National Farmers Union, Saskatchewan Coalition for Sustainable Development, SaskEV, Council of Canadians Regina Chapter, the Council of Canadians Saskatoon Chapter, the New Brunswick Anti-Shale Gas Alliance, and Youth of the Earth. Thank you for having received my errata, and I apologize sincerely for the blunder of in relation to the filing of my factum. So I'll first provide you with a brief overview of. I'll first be speaking to the record, the facts of this case. Secondly, my colleague Ms. Yee will be speaking to the living tree doctrine. Third, she'll speak to the precautionary principle. And last, time permitting, I'll make submissions with respect to Section 7 of the Charter. Before getting into the body of our presentation, I would like to quote a passage by Justice Dixon in Hunter and Southam, and that's at tab 3 of our condensed book. It's on page 155 at the bottom. In here, he's quoting Professor Paul Frund. Says that the Constitution is not to be read, we're not to read the provisions of the Constitution like it is a last will and testament, lest it become one. And that really summarizes our position. Turning to the record, and the first point that I'd like to make is that climate change poses an existential crisis, necessitating greenhouse gas pricing. It's our respectful submission to the court that we must be specific and explicit important material. Explicit gas issue to avoid by us. An emergent
Sorry,
dam the emergent
see.
of as an emergent is found. I think the point is businesses use the opportunity for a paragraph. Chief Justice Richard states that the fact
Act of Parliament pursuant to its powers as a matter of national concern. And that ultimately this court must take Section 35 and the honor of Crown into account in terms of its analysis. That is my submissions, pending any questions from this honorable panel.
On that point, just following up the general view that you've expressed, does the AFN see the possibility that Aboriginal communities could act as a bridge between the federal and provincial governments in connection with resolving the dispute short of federal legislation? In other words, if in fact the Aboriginal communities reached out to the provinces and have influenced all of them satisfactorily to Aboriginal people, then we wouldn't need federal legislation, would we?
Not in my mind at that point in time. We bridge the gap.
Right, and so the idea of a bridge there is not a completely foreign idea when developing, say, a new version of Crown Zellerback or something along that line. Am I out to lunch on this, by the way?
Challenge the Supreme Court of Canada in terms of Crown.
Yeah, that's up to them. But fortunately, we're in a kind of a Supreme Court free zone right now.
It could be an option.
Anyway, I was just interested in that. That's all.
And I was just interested in your submissions relating to the fact that, in your view, Aboriginal peoples have not benefited to the same extent in terms of the development of industry. And I was wondering how you saw that working and whether you believe that that was something that should be being done at a federal level, or whether this is, again, to follow up on Justice Watson's question, whether that ought to be done at the provincial level. You've got various treaties in various areas. Some of them are exclusive to certain provinces. And I understand that you would want, or maybe seeking perhaps, some accommodation on that issue going forward for the Aboriginal communities. Is it so?
I'll turn the matter over to
Yeah, I would say that would be correct. I mean, the issue that many First Nations have, of course, is Canada's use of the carbon space in the atmosphere is exhausted, and we're now borrowing from future generations. If First Nations were to start developing their economies and start relying on carbon-intensive gases, for instance, to catch up to Canada, to build our economies, that could be prohibited with respect to various governments, federal government, and even the provincial governments. So at this point, First Nations may be penalized unless, of course, we have access to cleaner methods of energy, for instance. In many Northern First Nation communities, there are no power lines for hydroelectric power in many communities. They rely on diesel generators.
Right.
Again, there has to be a change in the infrastructure to support First Nations economy and to build the resiliency that's necessary to address climate change. If things are left alone or the provinces don't provide that infrastructure, First Nations are pretty much left to their own devices. So we would feel that, all levels of government have a role to play, but particularly our relationship with the federal government has been the strongest linkage with respect to, interacting with Canada as a whole. So we would see that linkage as a necessary element as well.
So what you're saying is not so much can we go ahead and develop industries that might be producing greenhouse gases, but we require some accommodation of the fact that we are living in an inclement climate in many cases, in a sparsely populated area, far away from any major cities with economies of scale that they would have and we don't have. Would that be fair?
That would be fair for many First Nation communities in isolated remote areas. There are some First Nations, of course, that are close to urban areas such as Toronto. But clearly there is a diversity of realities for many First Nation communities across Canada that have to be addressed. And again, where you have a province failing to enact or to take action, the only government that's left to support First Nation communities is the federal government, should they choose to assist in those ways. Which is why we feel that, a national uniform minimal standards would go a long way to addressing climate change, but also to ensure that credits and other resources are available for First Nation communities to address that.
I hear you speaking specifically about the infrastructure, and you mentioned no power lines, and you're left to rely on other sources of fuel. And I understand what you're saying. What I would like to just be clear on is who you see as providing that infrastructure at whose cost. In other words, is this something that you would say if the federal government wishes to go this route, and you're arguing for the constitutionality of the legislation, but you're also saying, in essence, we'd like some reasonable accommodation made for the fact that we do live in isolated communities in perhaps less than, more inclement climates, far away from major population sources, and you're looking for support for the necessary infrastructure to transition to less carbon intensive ways of heating homes or whatever, and you want some support for that, I might understand then that you believe that that's something that should be provided by the federal government.
I believe it'll be provided by both governments in many areas. Like, for instance, if you're bringing in new infrastructure, power lines, highways, clearly the provinces will be responsible up to some point. Once it turns into reserve lands, which is under federal jurisdiction, obviously the federal government has a role in that. But it goes beyond just basic infrastructure. When you look at health facilities, for instance, many First Nation communities don't have proper health facilities. So the compounding nature of climate change impacts, especially with respect to vector-borne diseases and invasive species, that type of thing, it really, there has to be cooperation between all levels of government.
I take it what you're saying really is that it's time for the Aboriginal communities of Canada to be participants in the strategy session.
Yes, they have been part of the Pan-Canadian framework. They have obviously have been very engaged in a lot of environmental issues across Canada. First Nations obviously would share in the jurisdiction over environmental matters in many respects. They have contributed to various environmental assessment processes, using traditional knowledge to inform those processes, using our sciences has been developed over thousands of years. So clearly there is a role and they have been participating. The problem that we have, of course, is this fallacy that is either Section 91 or 92, which is has minimized the true potential First Nations could offer in many of these discussions.
Thank you. Any other questions that the panel has? And thank you very much for
I do
that.
have one request. Our flight to Toronto has been delayed, so they're trying to put us on an earlier flight. If we can beg the court's indulgence to be excused.
Oh,
Yes.
absolutely.
Thank you.
And now we have I guess it would be the final intervener, which is the Athabasca Chipewyan First Nation. And here representing the First Nation is Professor Ataran. Is that how you pronounce your name, Ataran?
Professor
Thank you.
Ataran, yes. Good afternoon, Chief Justice, Justices. I'm pro bono counsel for the Athabasca Chipewyan First Nation. I am also, as you mentioned, Chief Justice, a law professor who has taught environmental law and constitutional law. So perhaps at the end of my submissions, I could answer a few of the questions that, in particular, you, Justice Wakeling, posed, and you as well, Justice Fian, that weren't answered. So, but let me get into my submissions first. We'll leave that for later. The Athabasca Chipewyan First Nation is one that, of course, you're familiar with in the north of this province. Their homeland is and has been the Peace Athabasca Delta for at least 7,000 years. Their culture is a golden braid of lives lived, children born, traditional knowledge learned by them and perpetuated over that number of millennia. It is their intimate knowledge of the environment that is passed down through generations that has helped them avoid death in a place where most of us wouldn't make it. It's a very inclement place, as you've said, Chief Justice. And they've been able to survive thanks to their traditional knowledge of hunting, fishing, trapping, and so forth. These survival practices are integral to their culture. They're existential for their culture. They're sacred. And our Canadian culture recognized that in 1899 when we entered into Treaty 8 with them, guaranteeing the rights to hunt, trap, and fish. And then we recognized it again in 1982 by amending the Constitution to provide entrenchment in Section 35 to those rights, to those treaty rights of hunting, fishing, and so forth. We gave those rights constitutional ennoblement and gravity. The ACFN people are caught between their historical reality of the many thousands of years and their present identity. They are not trying to live in the past, in fact, very much in the future. For instance, ACFN is a lead business partner with Teck in the Frontier Oil Sands project. That is, for instance, Justice Watson, how they are a bridge. But climate change now threatens their past and present and their cultural survival. They need to be accommodated under Section 35. And if they're not, because accommodation is a requirement for the permits for the Frontier project, if a decision of this court impeded accommodation to the extent that they require to protect them from the effects of climate change, that would affect the approval of that project. Now, Canada's goal, of course, is to warm the climate no more than 1.5 degrees.
I'm sorry, before you go further, I guess I'm going to have to ask for clarification of what you mean by that would affect the approval of the project. What has the approval of the project got to do with the constitutionality of this legislation? What are we missing? Where's the link?
The link is that without this legislation, Canada is not going to meet its 2030 targets. That is essential accommodation for reasons I'll get into. They need the climate protected because without it, their homeland will be an overheated steam basket and a mess. And without that, I can't commit my client to one thing or another, or the federal government, obviously, but it would affect very likely the course of the Teck project.
Well, are you?
We're seeing it already. They call themselves the Etendelidené in their own language. It means caribou eaters. But to eat caribou, you have to be able to hunt caribou, as Treaty 8 gives you the right to do. Well, in recent years, in part because of climate change, the woodland caribou are threatened. They're listed on the Species at Risk Act federally as quote unquote threatened, which makes them illegal to hunt. They can't hunt. Something they've hunted for 7,000 years. That is their right. The barren land caribou, the only other population available to them, is recommended by federal scientists for listing as threatened, and probably will be soon. And when that happens, a 7,000-year-old connection they have with the land that is so integral to their identity they call themselves caribou eaters will be gone. Naturally, they need this accommodated. Climate change for them is existential.
But I understand you to say they're also a business partner with Teck on the Frontier project, and you began your submissions by saying that without this legislation, that project is in jeopardy. So without this legislation, what I understand you to be saying is, if there is no basis on which the federal government can see the possibility of meeting its targets, it will, I'm taking from what you're saying, I'm drawing an inference from what you're saying, and correct me if I'm wrong, that the federal government will not be willing to sign off, approve, whatever word one wishes to use, your client's proposal as a business partner with Teck on the Frontier project. So what you're saying is they'd like to go ahead with the Frontier project, and they'd like to ensure that they can do that. And in order to do that, set off against that is the need to ensure that we can still meet as a nation certain limits that Canada hopes to achieve.
Well, Chief Justice, you're eliding over a few steps, but I think rather than parse it piece by piece, let me make it clear in this way. It's existential for them. Climate change is utterly, undeniably existential. You don't change a temperature, an average climate, by 7 degrees where they live without disrupting the things that allow them to survive there. And if they have to choose the development and the positive aspects to the economy that Teck brings, or they have to choose between their survival, I'll leave it at that. And so their willingness to proceed with the project could be affected. Certainly the federal government's willingness of to proceed with the project could be affected. Because as Canada demonstrated, this legislation is sine qua non. If these reductions nationally are not made to emissions, there is no way, underscore, no way of meeting the 2030 targets. Take that away, whether legislatively, judicially, or by some other manner, and a great many things are in jeopardy. That's just a fact.
Well, what you seem to be saying is unless this legislation is upheld as constitutional, the federal government, from the inference I'm drawing from what you're saying, will not approve any new projects in the development of the oil and gas sector in Alberta.
I don't speak for the federal government, so that is not something I can say, but as a logical matter, yes, Chief Justice, it is a legal requirement that before granting any approval federally, the federal government must look at whether the accommodation and the consultation with First Nations has been satisfactory. And it is the ACFN's point of view. That's a must, no question about it. It's ACFN's point of view that without measures that are effective to stem climate change on their territory, they are not being accommodated.
Okay, well, then I perhaps have got, the nuance is a little different. I think what you're then saying is that if the legislation were not upheld as constitutional, any willingness on the part of CFN to become a business partner with Teck on the Frontier project or any other project is in jeopardy. Is that really what you're saying then? I'm assuming that's what, well, I'm not assuming, I believe that's what you're saying.
I'm not going to go further into the hypothetical. I'm sorry. I've told you what I can say on the matter, which is that for that project to go ahead, both as a matter of my client's wishes and as the federal law, which requires accommodation of First Nations people, where climate change is a significant feature of the accommodation or the avoidance thereof, it would be gravely mistaken to think that nothing turns on this legislation surviving or not. I cannot go further than that. I think if you wish to draw the inference that you've stated, you're welcome to. But I'm not standing here threatening in any way that if this legislation doesn't survive, that's it, the carpet is getting pulled out. What I'm saying is that rational people and rational federal governments will make decisions in accordance with whether the duty to accommodate which is constitutional is met.
I certainly didn't take it as a threat. I took it as an indication of a factor which would influence the decision whether to proceed or not.
I'm certain it will. I'm certain it will, for the reasons already stated.
That's what I'm trying to say, that
I'm
I
certain that it
understand you to be saying, which is, unless this is upheld as constitutional, there is a risk that the willingness to proceed with this may not be there in the future. I think that's fair.
I think that's fair. So, with respect to the constitutional question, ACFN's belief is that the court must consider the 1867 and the 1982 Constitution together, in part for the reasons we've discussed. The constitutional question asks if GGPPA, the Act, is constitutional in whole or in part. It doesn't say the 1867 Constitution only, so it does implicate 1982. And there's two cases that are quite important as to the intersection, the manner in which the 1982 Constitution and 1867 Constitution come together. One is the Quebec veto reference, where the unanimous Supreme Court said, quote, "The Constitution Act 1982 directly affects federal-provincial relationships." Directly affects federal-provincial relationships. It affects 91, 92, 92A, and that's a unanimous Supreme Court. Likewise, in the Quebec secession reference, not the veto reference, but the secession reference, quote, "The individual elements of the Constitution are linked to the others and must be interpreted by reference to the structure of the Constitution as a whole." What this means is you're directed by the Supreme Court certainly to interpret 91, 92, 92A, of course, but you must do it harmoniously with Section 35. And when you do, when you seek that harmonious interpretation, it militates very strongly for this act being constitutional. Why? But for the act, a province that fails to control greenhouse gas emissions effectively would further infringe or perhaps extinguish Aboriginal and treaty rights, hunting, fishing, which themselves are constitutionalized under Section 35. The Crown needs, speaking of the honor of the Crown needs to have the ability to set a standard that allows the Section 35 rights to be least impacted. If it doesn't have that ability, because of how 91, 92, and 92A are parsed, then in effect, the Crown is violating treaty rights, constitutional rights. Or to look at this in the converse, suppose that the court found the act unconstitutional because of something in 92 or 92A and struck it down. The result would be increasing GHG emissions over the target that further infringe or possibly extinguish treaty rights. It would turn the Peace Athabasca Delta into a steamer basket. It would kill off the hunting and fishing that is a constitutional right. And in the result, you'll have solved one constitutional problem about this act and created a further constitutional problem about the violation of Section 35. And I put it to you, that has little to recommend it. It's just not wise to solve a constitutional problem in a way that begets another constitutional problem.
Is your position that it's only the federal government that can do what you say has to be done, and that is to take the necessary steps to prevent the steamer basket scenario, as you call it?
The record before you, Justice, is that without this act, Canada cannot meet its targets. And if you want further evidence of that, I won't take you to it. In the cross-examination of Mr. Savage, Alberta's affiant, he admitted in cross-examination that Alberta has no plans, whether actual or even modeled, to reduce emissions 30% by 2030. That's page 71 of his cross-examination transcript, lines 16 to 22. So without the federal role, Alberta has admitted, we do not have a plan, real or even modeled, to make that reduction. With respect, particularly Justice Watson, with respect to your question about First Nations somehow being caught in the middle between the federal and the provincial and whether they could serve as a bridge of a kind. Well, one way is through engagement in projects like tech. Mm-hmm. But another thing you must bear in mind, please, is what Justice Dixon, Chief Justice Dixon, pardon me, said in Mitchell and Peguis band. Mm-hmm. He said this, quote, "From the Aboriginal perspective, any federal provincial divisions that the Crown has imposed on itself are internal to itself." Mm-hmm. In other words, the Crown's indivisible. It's always Her Majesty in right of somebody, but it's still Her Majesty. That's the Crown. And it would not be correct to view watertight compartments where there is a concurrent Section 35 question to say who's responsible for the First Nations. A watertight compartments view of the Constitution is not just misguided, it's obsolete since 1982. You must use the double aspect doctrine. And when you do, you must assign responsibility for GHGs, greenhouse gas emissions, to the province and the federal government. This is the only correct way, for reasons that Canada has very ably submitted, but it's also the only way to preserve vis-a-vis the Aboriginal people of this country what Chief Justice Dixon said, that the distinctions of the Crown that it has imposed federal provincial are internal to itself. The honor of the Crown requires action by both. To do otherwise is to do what the Supreme Court of Canada decried unanimously in the case of Daniels, where they condemned the, quote, jurisdictional tug-of-war, close quote, which leads to a, quote, jurisdictional wasteland for First Nations and Aboriginal people. With respect to POG, I'll be quick on this. We put it to you, beyond the submissions you've heard on national emergency and national concern, that there is the new matter branch. Several of you referred to the new matter or gap branch of POG. It's the same thing. We put it to you that anthropogenic GHGs, CO2, warming the climate, the fact that anthropogenic CO2 can warm the climate is a scientifically new matter since Confederation. CO2 has been around forever, of course, but the understanding that humanity's emissions of CO2 can change the climate, that is scientifically new, and nobody had a clue of it in 1867. In Canada's...
Can I just ask whether you would say the same thing about the amendment of the Constitution to put in Section 92A? Is our understanding and knowledge of the effect of greenhouse gas emissions on global warming post-dating that amendment, 92A amendment? From your point of view?
No, it's not.
From
It's not post-dating 1982. But 92A is about primary production in the province, right? And the essential feature of greenhouse gases is they're not in the province. they travel, they get out of the province. You asked the question, Justice Fee, and yourself, what about these treaties that span provincial lines? Primary production is different than secondary emission. So I really question the applicability of 92A to this case. We are talking not about the production, we're talking about the emission, and the emission, unless Alberta could build some very steep walls around its borders, will leave the province. You've probably heard about carbon capture and storage technology. Assume for a moment that Alberta produced everything it does, but also captured all the emissions and kept them here. We wouldn't be having this case.
But the fact is that every emission can leave the province, and probably does, because the world spins. So there are emissions from other than the oil and gas sector. Let's take the cattle industry as a good example as well. So those are emissions, and the people living are emissions. So this goes on, and the idea that somehow the only emissions we're concerned about here are ones from the oil and gas sector appear to be a little bit misplaced too, in the sense that it isn't just about the oil and gas sector, it's about everything. And what the federal government actually argued in Saskatchewan is the cumulative dimension of everything. So it is everything. So the idea that somehow this can be separated out, and this is sort of sufficiently something that by itself, it's the only thing traveling and the rest of the emissions are not traveling, is not really so, is it, Professor?
With respect, Chief Justice, I disagree with you. Because I think to say that all emissions are the same and they all travel engages in a great scientific oversimplification. There are scientific reasons that certain GHGs have been selected for this act.
But isn't one of them methane?
Yes. But, you know, there are many things that are released that remain local, and to the extent they're a nuisance or a danger to health or some such, they're local contaminants, local pollutants, and then there are the long-distance ones. And this is a matter of chemistry, of physics. It isn't satisfactory to simply say, because all emissions get out of the province, which in itself is incorrect, that then this act must be viewed in such a broad manner as to make it unsustainable. I respect that may be your opinion, and I respectfully disagree with it. And I don't think that the body of environmental constitutional law begets that sort of analysis.
Well, my understanding is that methane is one of the ones on the list. My
It is.
understanding is also that that's produced by the cattle industry.
It is.
And I guess, are you suggesting to me that then the methane is not one that travels, but the other ones do, and the methane remains only in the province of
That's not what
Alberta,
I'm
the
saying.
emissions?
No, that's not what I'm saying.
No,
I'm
well,
saying
that's
that
not what
the
I was
one-
saying either.
Okay, well then, what I'm saying is that the ones that are on the list are the ones that have as a common feature, this is their singleness, distinctiveness, indivisibility. They travel across jurisdictions, they're persistent in the atmosphere, and they trap heat. And this is nicely explained in the affidavit of John Moffat, I believe it is, in Canada's record. These geophysical chemical properties allow you to say GHGs are in fact distinct. They're not like the muck that spills into a river necessarily, although some muck, as in the interprovincial cooperatives case, does travel rather far across provincial borders. It's not like a tannery next door. So many of the early common law nuisance cases were about tanneries. These emissions are different. They have been selected by scientists around the world for reasons that ought not to be gainsaid in a court by simply equating them with other emissions. They're selected based on real scientific differences of their chemical and physical properties.
The objective, of course, that was chosen under this act is pricing control to change behavior to then lead to some reduction in consumption and production of the kinds of GHGs you're talking about. There's a variety of steps, which I think you fairly pointed out. But I'd like to bring you back to a legal point, just to make sure I understand, because there's one thing that's quite important that we have to bear in mind, and that is that while you're correct that the reference is very general, and does raise a whole variety of constitutional points. There is a rule of prudence, shall we say, that does arise in connection with constitutional litigation. And let me explain what I mean by that. Because I think it relates partly to your Section 35 arguments, of which I find two. The first argument that you make is that Section 35 should, in effect, inform the interpretation and application of Sections 91 and 92. In other words, it should assist us in assessing the scope of those and whether or not over time, and as you may recall, just a minute, as you may recall, at the very beginning, I actually suggested that something about Crown-Zellerbach that may be defective is its failure to acknowledge that those things can grow too. And so, in that sense, like the predecessors, immediate predecessors, the suggestion may be, well, Section 35 can help in that sense. So I can see the adjectival role, you might say, for Section 35. The separate Section 35 argument, though, that you've put forward is the one for which the rule of prudence might apply, by which I mean you're saying that even if this law fails on 91, 92 analysis, as upgraded and all the rest of it, then you would have to look at whether or not Section 35 itself is a freestanding question that brings into, because of the concern you mentioned about accommodation and so forth, which I'm not trying to trivialize, by the way. I'm just saying, taking through the structure, right? You understand? Do you think, is it your submission, that in the context that we have here, with the type of record we have and submissions we have, that it would be wise for us to try to embroider this judgment with a discussion of how Section 35 might by itself raise a constitutional, you've raised it, but should we?
I believe I must correct a misunderstanding.
Okay.
I'm very much with you on your first point.
Right.
Extremely well taken. That Section 35 operates in such a way that it affects one's reading and one's interpretation of the Constitution Act 1867. You mentioned 91 and 92, but that's also 92A.
Right. That's what I meant by that. Yeah.
I'm with you on that first point. I'm not asking you for a freestanding Section 35 decision, which is your second point. All I'm asking you for is that, well, let me put it this way. For example, when you interpret POG, the National Concern Test, the national emergency, you have to interpret that in a way that comports with the limitations that Section 35 places on the Crown. And one way of doing that is, on your outstanding point of perhaps Crown-Zellerbach needs a facelift. One way you might give it that facelift is to say the national concern test, the national emergency test, whose nation? Whose nation are we speaking of?
Well, because let me just make one point. Yeah. You have to understand that we're not completely isolated from the law. I read Grassy Narrows in the 2014 decision, which does sustain your point concerning the respective obligations of levels of government. And so in that sense, it does seem to me that, as you fairly point out, we maybe have to upgrade Zellerbach, for a variety of reasons, both directions.
Justice, I can promise you this.
Yeah.
When I get to the Supreme Court,
I won't be there.
I'm making the point that Zellerbach needs quite a substantial facelift. While its core tenets are sound, it came about before Section 35 was really a big part of our constitutional landscape. It postdates 1982, but Section 35 wasn't very well developed when that decision was handed down, when Zellerbach was handed down. And so certain questions have to be asked about it, not to reject it, but to reframe it. When one speaks of a national concern, whose concern? Does it require the Canadian nation as a whole to be a concern? I believe, Justice, you asked, what if a meteorite hits in the north? Was that you?
Somebody did, maybe.
Oh, I'm sorry.
I'm guilty of that one.
I'm sorry. Okay. Well, when your meteorite comes to the north, it might affect a First Nation differently than how it affects the nation as a whole. It might be an awfully big national emergency for the First Nation. a nation in its own right, and less of an emergency for Canada as a whole. Would we in that circumstance say, this can't be addressed through national concern? I should hope not, because if that were the case, then a tsunami or a massive earthquake that hits Vancouver couldn't be a national concern because it doesn't affect the whole Dominion all at once. In the reinterpretation of Crown-Zellerbach that may or may not happen, part of it, I think, should be whose nation? Because First Nations are sovereign nations in our law. Likewise, whose emergency? These are important questions. And, you know, were one to reimagine the general residual power, the POG power, you'd have to start with the premise that it was one trunk at one time. It's a single power in our Constitution. It has grown 3 branches: national concern, national emergency, and new matter, or gap, if you prefer. And we tend to speak of these as being disjunctive. Query, is that right? Because once upon a time in our jurisprudence, we didn't look at it so much that way. Canada Temperance
There's only one
Foundation.
gap. As Justice Wakeling points out, there was only one gap.
Yeah, right?
I still think that. It's,
Well, and
the residual power, if the residual power, anything that falls into it is, could be National Capital Commission, not listed in 92. Could be anything that's not of the same kind of quality as the enumerated powers. It's all residual power.
Justice, this unified view of it that you're espousing has been true at certain times. It was true in Canada Temperance, and in cases such as Johannesson, which is the aeronautics, I love the old word, aeronautics case, the radio reference, those were placed under the general residual power, aeronautics and radio, because they were new matters. And one did not look much further than that. And I submit it is open to you as a court to say, anthropogenic climate change is a scientifically new matter. None of the fellows in 1867 had the least inkling. It wasn't theorized until 1904 by Svante Arrhenius that you could affect the global climate by emissions, and it wasn't proved with evidence until the 1950s in the work of Professor Charles Keeling. This is summarized in my affidavit, in my factum. It is drawn from the work of 2 historians of science, Professors James Fleming and Spencer Wirt, whose works are published in the Oxford University Press and Harvard University Press and excerpted in the Materials of Canada. I heartily recommend to you those chapters because that will give you the foundational basis to say, indeed, this is a new matter. And then it would be open to you, Justice Wakeling, to decide in the manner you're proposing.
Could you explain to me then the difference, or how you would see a difference between environment and greenhouse gas emissions?
Well, environment, a good place to answer that is the definition of environment in the Canadian Environmental Protection Act, and it truly is everything. Every living thing, every non-living thing.
Flying rocks?
Huh?
Flying rocks, as the Ontario said?
Flying rocks?
Rocks, yeah.
So
that's part of the environment too.
So we're back to asteroids.
Explosions and rocks.
Right?
Yeah.
Right. The definition of environment, like this. Greenhouse gases are a subset of the environment, a subset of gases in the environment, a subset of which is persistent for a period of time in the environment, and a subset of which traps heat and warms the climate. It is an infinitesimal shred of the environment. In point of fact, currently there's about 400 parts per million, a bit more than that, of carbon dioxide in the environment, in the air that we breathe.
I take it you're saying that environment could not by itself be a head of power.
Certainly not.
It has a scope that isn't comparable to any head of power that's listed in 91 or 92. It would be like saying the federal government is responsible for the happiness of Canadians.
And
you just couldn't do it. Doesn't work.
Justice Wakeling, your incredibly knowledgeable teacher, and you were lucky to have him. Professor Letterman had something to say about this. And it's in tab 7, volume 2 of British Columbia's Book of Authorities. There's an article that Professor Letterman wrote on Canadian federalism. And in it, he says this: a prohibition against emitting noxious chemicals from an industrial plant into a river, for example, so pollution, may be logically classified as property law, criminal law, fisheries law, pollution law, environmental law, recreational law, blah, blah, blah. And that's your point, that environment doesn't fit into any of these. But what he goes on to say in that article is, he says, after you look at the 46 heads of power in 91 and 92, and now I guess it's a few more, 92A, after you look at those heads of power, and you fail to find that the dominant characteristic, the pith and substance, fits a single one, which is definitely the case here, he says, quote, in terms of the social needs and facts of the country, then as a second step, you consider invoking the federal general power. Professor Letterman said that's when you go to POG. And he said you could do that if 2 conditions are met. That, quote, the new subject must, as a matter of evidence, arise out of the needs of our society as something that necessarily requires country-wide regulation at the national level. I submit that's true here. And second, that this new subject, quote, should also have an identity and unity that is quite limited and particular. Justice Hughes, GHGs are a minor subset of the environment. They do have that identity and unity that is limited. That satisfies Professor Letterman's formulation. And I think his approach in this article and the passages I've read to you, I hope you look at the whole article later, is sound.
I've read it.
Okay. But that's where he speaks about pollution, and it fits this case to a T.
Well, thank you, Professor. I think you've overshot your time, but you did a fine job.
Quite a bit.
You did an excellent job, and it's been very helpful and very enjoyable to, we had the benefit of somebody giving us a good lecture on, thank you very much.
Can we record that and send it to my students, please?
No, absolutely.
Thank you.
Very well done. Thank you so much, Professor. We'll take a break now, and then we will return at that stage to hear from Alberta. And Council, you, from a timing perspective, I don't, how much time did you think you would need? And I'm not pressing you to say it has to be done quickly.
I don't think any more than 45 minutes, maybe shorter.
Okay, thank you.
Order in court.
Order in court.
Mr. Gall.
Thank you. My ladies, my lords, before I get started on my submissions, Ms. DeMarco asked me to bring something to your attention. Yesterday, she was asked, she said she'd get back to you. Actually, I thought it was probably better for her to say it, but anyway, I'm here to pass on the message. She was asked yesterday about an authority for the proposition that you could find an act constitutionally valid. I'm reading her note here. You could find an act constitutionally valid, and later it could notionally be open for an entity to challenge its applicability based on evidence that the core of Section 92A was impaired. And she says there is an authority. It's Canadian Western Bank at paragraph 35, tab 3, volume 1 of Alberta's Book of Authorities.
Are you getting a fee for that?
I don't know.
They're probably all over the limit by now.
I'll try to be brief. I just want to make a few comments, which I hope are helpful to you in your deliberations. And I'm going to start with some comments about the subject matter and pith and substance, just responding to really the arguments of Canada and BC. I also want to pick up on a question or a point of Justice Feehan yesterday about the reading of Crown-Zellerbach and the overlapping and Dale Gibson. I want to pick up on that. I want to make some brief comments about provincial inability or failure, and I really just want to pick up on something that my friend Mr. Morley said today about a proportionate balancing of the evidence, the effects, both extra-provincial and intra-provincial, and really just point out or pose the question, really, of what that would mean for the court. What sort of undertaking would that require a court to engage in? And finally, we have a couple of evidentiary points, and my colleague, Mr. Delansky, will briefly refer to those, just to correct or to supplement the record so we can be best ensure that you have the information you need to make your decision. So, but I want to start with on the issue of what I've called subject matter or pith and substance by just saying this. I think particularly when we heard the interveners in support of Canada today, made it very clear that the subject matter, the matter of national concern, is greenhouse gas emissions and its effect on the environment and the effect on climate. That's what we're talking about. And the argument is, in its broadest form, and Canada and BC have tried to narrow it in order to try to fit it within constitutional doctrine, but the argument is essentially that Canada has to have this power, just has to have this power, because that's the only way we're going to be able to achieve the goals, the targets, the national objectives of our country. And I want to say 2 points, just make 2 points, and I'll touch on these points in my subsequent submissions. But first of all, I don't think it's fair or accurate to say that it's borne out on the record that this is the only way that Canada is going to be able to reach whatever objectives it has as a country in terms of reducing greenhouse gas emissions. I don't think it's borne out that leaving it to the provinces to try to deal with the problem in their own way, which, as we've heard from Manitoba, they think they've got at least as good a way. Ontario says we've been very effective in other ways in reducing greenhouse gas emissions, which we're not given credit for. Saskatchewan says the same thing. Alberta says the same thing. But I don't think it's borne out in the record that the provinces aren't able to work together in some cooperative way, doing their own thing to reach whatever objectives Canada might have at any particular point in time. That's the first point. And the second point is really where I started my argument on the first day, is that we have to be really, I think, really concerned, conscious here of not distorting our balance of powers, our constitutional system, the foundations upon which the provinces came together as a nation. And so with those just introductory comments, I just want to now make some general comments about subject matter and pith and substance. And I think it's significant to note that Crown-Zellerbach, you won't find the term pith and substance in that decision. They didn't apply a classic pith and substance analysis, certainly not using that term. The court there referred to the subject matter. It looked at what the statute covered, the dumping of pollutants into marine waters. That was important. The question was whether that subject matter, that matter could be fit within, or was a matter that came within the national concern doctrine so as to justify the statute as an exercise of federal power. And as we know, we've gone over, and I don't want to belabor this, we know that the court found that the subject matter of marine pollution, or the dumping, the dumping of pollutants in marine waters, came within federal jurisdiction and not provincial jurisdiction. That's what they found. So that was that case. In anti-inflation, again, Justice Betts did not describe the pith and substance of the act. He did use those terms. He didn't describe it as saying it was setting minimum standards for price controls and other measures in order to reduce nationwide inflation. He referred, and I think this is most significant in his decision, he referred to the subject matter of the act as inflation. He said it was a matter of national concern, but he found that inflation and control of inflation didn't fit within the national concern doctrine. And why was that? It was because, as he put it, and this is the way he described the pith and substance of the act, in essence, this was the exercise of provincial powers, and specifically the provincial powers over property and civil rights. That's the way he described the pith and substance of the act. He described it in terms of the provincial powers and the impact on provincial powers. So, and then we have Hydro-Quebec, where was the minority, as we know, because the majority didn't deal with the national concern doctrine. The minority said, and I'm quoting, that the pith and substance was, quote, the wholesale regulation by federal agents of any and all substances which may harm any aspect of the environment or which may present a danger to human life or health. You can see how broadly they defined the pith and substance. And then they went on to address specifically whether the chemical substances or toxic substances as defined in the Act were a matter of national concern. But the important thing is that, and we see this in all of the cases, the specific means chosen to regulate these toxic substances, or the fact that there was no mention of them being national standards or national requirements or minimum requirements for chemical pollution. None of that was discussed. And in fact, in none of the cases did the court adopt the type of highly detailed pith and substance analysis that BC contends should be done. And they didn't add words like nationwide or national standards to attempt to fit federal jurisdiction under the national concern doctrine. And nor were the specific policy means that were used or the efficacy of these measures of any relevance in those cases. And why is that? I submit it's because you're not adding a specific statute with specific means to the list of federal powers. What you're adding is a subject matter. And you only add the subject matter if it fits within the narrow confines of the national concern doctrine. And that is when it's a narrow, single, indivisible matter that's clearly distinct from provincial matters, and where adding it to the federal list of powers would have a scale of impact that is reconcilable with the overall division of powers.
Well, I'm going to just interject here to ask some questions that I think I'd like to have some help on your zeroing in on in reply. You've heard Professor Adaran and his proposition that this is a this can be justified on greenhouse gas emissions on the basis that this is a new matter, having regard to its identification in the early 1950s, and more recently the recognition of what's happening with greenhouse gas emissions. So what do you say in response to his argument that this is a new matter and it is therefore indivisible, it has that degree of distinctness, et cetera, that's required?
Okay, using his analysis, and I don't deny that this is new in the sense it wasn't contemplated in 1867 and really has only come into a clear focus for everyone in recent years. I don't deny that at all. But then where do you go from that? That's just the starting point. The next point is it a new matter of national importance? And I'm going to come to that in a moment when I go through briefly BC and Canada's arguments. And then if you get over that test, you go into, okay, can we separate it from provincial powers in a way that's reconcilable with our overall division of powers? So saying it's a new matter only gets you over, I guess, one of the, well, it is the first hurdle. But I come back to the way they describe the new matter. It's greenhouse gas emissions and its effect on the climate and the environment. And so really you can't, I mean, in listening to my friends, other than Canada and BC, and even BC, and I'm going to come to this in a moment, when pressed about the national concern, it was about the global climate. It wasn't about specific means to reduce greenhouse gas emissions. So that's really what this is all about. And then the question is, okay, can you take greenhouse gas emissions and give that power to the federal government in a way that wouldn't just trample provincial power? And we know from Saskatchewan and Ontario, the majorities there, they said, no, everybody said that's going too far. That's too pervasive and too invasive of provincial jurisdiction. And hence, now we get into the need, okay, is there some way we can narrow it without having that effect? But to take Professor Adarand, yes, it's a new matter, but if you accept everything he says, it's a matter, it's in its entirety, in his view, has to be regulated by the federal government. And that is a serious, significant encroachment, distortion of provincial powers. And again, I come back to where I started. I don't think it's borne out in the evidence that that is the only way or even the best way of dealing with the new matter, the challenge of reducing greenhouse gas emissions.
Council, what happens if this was the situation? Suppose the Green Party is a governing party in all 10 provinces, and we've got a federal government that is not near as interested in climate change matters. How do we deal with that? We then see all of the provinces using their powers to the maximum to take care of greenhouse gas emissions. And you're saying it's conceivable that in that scenario, we'd be just as effective as if we had a federal government that was committed to diminishing greenhouse gas emissions. Am I reading you?
Well, I think you're right, but I think the implication of where you're going takes it in another direction. But first, you are right. I do say that the provinces, at least there's no evidence. And my colleague, Mr. Delansky, is going to take you through the history of this to clarify it in terms, because the suggestion is being left that somehow this got off the rails and they had to, the federal government had to step in. I don't think that's a right, accurate description, but leave that aside. But I think the implication is, if in fact it's greenhouse gas emissions that is the subject matter and is such a national concern, that even though it's distorting the balance of powers, it's now within the power of the federal government. Under the scenario you just described, the provinces would be powerless to deal with it, because it's now, and this gets back to Justice Fian's question too about overlapping concurrent and whether that's even possible. And under the doctrine, that isn't possible. And now you have this broad subject matter of the control over greenhouse gas emissions residing with the federal government. And you look to see what Justice Betts said about inflation. He said, well, once that's within federal jurisdiction, the provinces can only, at the corners, at the margins, regulate. And we see, for example, this is jumping ahead to answering Justice Fian's question, but you see in cases like aeronautics or radio communications, we had the Rogers case, the Lacombe case, and that shows the exclusivity, that the provinces then can't pass laws whose pith and substance or dominant characteristic is aimed at that federal undertaking, aeronautics or radio communications. They couldn't regulate where you put a radio antenna. They couldn't regulate where you put an aerodrome in those cases, which just shows, going back to your example, that if in fact you take Professor Adarand's view of the scope of the power or the nature of the subject matter and how broad it is and pervasive, then the provinces, they don't have control over it anymore, not only to deal with it in terms of the needs and circumstances of their own residents, but even collectively as provinces getting together and trying to determine what should be done nationally. If the federal government isn't in step with them, doesn't want to do it, doesn't want to go that far, has a different view, That's what you've done when you've now turned this matter, just like aeronautics and radio communications, over to, or added it to the federal list of powers, because it's not a matter coming in within the exclusive jurisdiction of the provinces. And I just wanted to just finish this point by taking you to Professor Letterman, again, in his Unity and Diversity article, because, and this is, by the way, volume 4 of the Book of Authorities of Alberta. I don't know if you have that handy. If you don't, I'll just try to read you. It's fairly long, but I'll try to read it to you if you don't have it handy. It's volume 4, it's tab 31. And the passage that I would like to read is found on page 606 and 607. And if you got that page, it's halfway down on 606. It starts, note that whether we are assessing the impact of the 46 specific subjects listed in the British North America Act, or considering the possibility of adding a new subject to the federal list, we are not simply engaging in philosophical speculation at large about the many dozens or indeed hundreds of logically possible classifications for the challenged law. Yet this latter range of logically possible classifications cannot be entirely ruled out of the process. Council seeking to invoke the federal general power in order to support a challenged federal statute on a new basis will search the whole range of dozens or hundreds of philosophically relevant classifications in order to find the one unlisted class that may serve their purpose, the one which they can then propose as a new subject for the federal list by virtue of allegedly sufficient evidence of social fact and social need for this type of regulation at the national level. If we now shift from council to the judges, we have an alternative statement of the basic problem. By what test do the judges determine the success or failure of such propositions from council about a new subject? Then he says, perhaps I can clarify this with the example of aviation. Both the Judicial Committee and the Supreme Court of Canada have held that aviation was a subject that deserved to be added as a new specific category to the federal list by virtue of the federal general power. Why did they do this? Because technologically and industrially, aviation has a factual unity as a transportation system and implications for transportation as a force in the life and development of Canada that make provincial boundaries frustrating or irrelevant in relation to the legal regulation necessary. Then he goes on to talk, read the judgment of Lord Sankey in the aeronautics case of 1932 and that of Justice Locke in the Johansson case of 1952, and you will see this reasoning well expressed, especially in the words of Justice Locke. This illustrates the way in which new subjects win entitlement to be added to the federal list. And then I'll just leave the rest, lead you, but he goes on to say at the end, the last paragraph on page 607, why should it be very difficult in principle to invoke the federal general council? Because it is essential in our federal country that the balance between federal and provincial subjects of primary legislative powers should remain stable.
I think we understand that. I take your point to be that the double aspect doctrine, in your view, does not give much room for the provinces to maneuver, because the way in which the federal government has set it, if you allow for minimum standards, means that the options available to the provinces are necessarily limited. Is that what you're in essence saying?
Yes and no, but let me just state, I want to go back to Lacombe and Rogers, because it's very important. There's no overlapping concurrent jurisdiction here. And you can see, it wasn't open to the provinces to regulate where they put up a radio antenna or that. It's only at the margins. Double aspect comes in, paramountcy comes in, interjurisdictional immunity comes in, when you've got both heads, levels of government being able to regulate in a certain area, in a certain matter, albeit from different perspectives. And that's where it comes into play. It has no operation here, given the exclusivity of the power once it is added to the federal list. That's our point.
Okay, I guess that I understand your friend's point to be, and the argument that's being made is that even though it would fall within the exclusive jurisdiction of the federal government, as with other powers, whether given to the provinces or the federal government, where the jurisdiction is exclusive, there is still room for the double aspect doctrine to operate, and still room for either level of government to operate within that subject matter.
There is no room if the power is added to the federal list under the national concern. It's exclusive. And it's by definition, it's exclusive, because it's not a power fitting or falling within the exclusive jurisdiction of the provinces. We go back to the wording of the preamble. It's not a matter coming in within the exclusive jurisdiction of the provinces.
Well, then, okay, this takes us back to, I believe, where we started as a court yesterday, which was in asking the question whether, if something fell within the exclusive jurisdiction of the provinces, it followed that it couldn't be the subject of national concern.
Well, we did discuss that yesterday, yes. And you suggested, I think I agreed, that that you could read the first point of Justice Ledain's decision in Crown-Zellerbach as saying that the national concern doctrine really only came into play if it was a matter being justified by the provinces under its residual power. I think when you pressed Ontario on that, they said, well, and I think Ontario's probably right, that's not the absolute limit. There can be other situations where a matter might be said to come within property and civil rights, for example, but because, and to use the way Professor Lederman described the aeronautics case, because of all of the features of that subject matter, it really wasn't within provincial jurisdiction. But the point is that under the POG power, national concern, if it's added to the federal list, it's not in the provincial list. It's just not. And sorry.
As I understood the Government of Canada yesterday, because we asked this, maybe I got it wrong, but I don't think so. I think she acknowledged that just because a national concern is added to the list of federal powers doesn't mean that the province doesn't have an interest. So in other words, it's not a trump. And if it was, it would be the only one, the only federal power that had that trump capacity.
Well, I'm going to
if that's not the case,
it's just not the case. It can't be. And that just shows the limits of the national concern doctrine. If it is added to the federal list, it's not on or in the provincial list.
I must admit I don't follow that, because there's a long list for provincial powers and a long list for federal powers, and almost every law you can imagine has dimensions that are on both of those lists. And
but see, how did they get on the federal list? They were there from the beginning, and that's the difference. This is not an express power, express federal power. It's a power that it's a residual power.
That's been there right from
But it's a residual power that the federal government has because it's not in relation to a matter coming within provincial power. This is jumping ahead to Justice Fian's question, and that's Justice Betts' decision. in anti-inflation. And I have that at tab 2 of my brief. And I just want to take you, Madam Chief Justice, you took us all to another paragraph in the decision, I think from Justice, well, a little later on in the decision, but I want to take you to page 33 of the decision. It's in our condensed book, tab 2.
Condensed book. Where is it in your original book? Because I have it all marked up. Which volume is it in?
But I'll have to ask you. Our original book of authorities, anti-inflation.
Which volume?
I'm just going to find out here.
Tab 2.
Volume 2, thank you.
17.
Sir, tab, I'm told it's a tab 17. Is that volume 2, Stephen?
It is. It's volume 2, tab 17.
Yes.
And what page?
Page 33. And it's near the bottom of the page. It's really at that end of the paragraph that begins in the middle, that long paragraph. And about 10 lines up from the bottom, you'll see a sentence that begins, furthermore. And I think this is the answer to Justice Fian's question, and why it is that Justice Ledane didn't make a mistake in reading the anti-inflation case. Here's what Justice Betts says. Furthermore, all those powers would belong to Parliament permanently. Only a constitutional amendment could reduce them. Finally, the power to regulate and control inflation as such would belong to Parliament to the exclusion of the legislatures if, as is contended, that power were to vest in Parliament in the same manner as the power to control and regulate aeronautics or radio communication or the power to develop and conserve the national capital.
Could you just take me to page again? I just want to
Page 33.
That's right at the beginning, the first submission, these heads of powers. What's the first?
Well, that's page 32. Well, yeah, I guess maybe we have
I'm
different
probably
versions.
on a different page.
But it starts under that heading, and then that first submission, and then it goes, is it different? No, it's the right page. Yes, it is. I think it's on page 33 in this volume 2. It's after the listing of the various subject matters. There's a couple of shorter paragraphs.
Yes, and then it's if the first submission is to be
Yes,
accepted?
that's to be accepted, yes. And you go down 10 lines from the bottom, right-hand side, and it's a sentence that begins furthermore.
I see furthermore now.
Yeah.
See where you are. Carry on. All those powers would belong to Parliament permanently. Only a constitution amendment could reduce them.
That's right. And then it says, now, and it shows how limited the scope of provincial powers are. He says, it's in the same manner as the provinces could probably continue to regulate profit margins, prices, dividends, and compensation if Parliament saw fit to leave them any room, but they could not regulate them in relation to inflation. And that goes back to Rogers and Lacombe. They can do some incidental regulation relating to aeronautics but if the pith and substance, if the dominant characteristic is aimed at aeronautics.
Bring it home to this case. What are you saying that means in the context of this case?
Well, okay, we have to take it step by step. Obviously then, if the subject matter, as we say it is the regulation of greenhouse gas emissions, if you take that and give that to the federal government, it's exclusive. And then with respect to those matters relating to greenhouse gas emissions, and remember how all pervasive what the majority in Saskatchewan said, look, this would involve anything and everything that's going on in the province. It would mean that the province, in relation to those activities, could only regulate at the margin, but not in any way where the dominant characteristic of their legislation was the regulation of greenhouse gas emissions. There can't be any overlapping or concurrent jurisdiction over that subject matter that's added to the federal list through the national concern doctrine.
Your main position, if I've got it right, is there is no federal class of laws involved here because the national concern doctrine is not engaged.
Absolutely, there is no, no, they can't justify it under criminal law.
If you're right on that, you win.
That's our view. Yes, absolutely.
There's no way the federal government could win if they don't have any head of power that's involved.
No, and they can't win either viewing the subject matter in its reality, the reality of the subject matter, as Justice Betts put it in anti-inflation, which is greenhouse gas emissions. And they can't win either by trying to narrow it the way they're doing it. And let me just explain that, because I think this is an important point. And let me take it step by step. First, dealing with Canada. The first step, as we know, is identifying whether there is a matter of national importance. That's the first step. And Canada agrees, and they say, and this is I think it's very important, the differences between Canada and BC and how it's approached. Canada says, and I'm just quoting, that the matter of national concern is the establishment of minimum national standards that are integral to reducing nationwide emissions. That's the matter of national concern. Now, that, with respect, is the same as saying that the matter of national concern is the regulation of greenhouse gas emissions. It's exactly the same. Calling them minimum standards doesn't change the fact that what we're talking about is the regulation of greenhouse gas emissions. It doesn't narrow it. So it's the same problem. You know, Canada had that problem before. They started off, it's greenhouse gas emissions, then it's the cumulative effect or addition. But this doesn't, and both courts before said, well, that doesn't overcome the pervasiveness of the scope of the matter and the scope of the power that you want added to your list. And putting the words in there, minimum national standards, doesn't change that. Just doesn't change it. So let's go then to BC. BC, it collapses, as you recall, the pith and substance and the subject matter. It says it's one and the same. And they say that the pith of substance, I'm just quoting again, is establishing minimum national pricing standards to allocate part of Canada's overall targets for greenhouse gas emissions reduction. So what they've done in order to get over the pervasiveness problem, and really what it does is create this concurrent or overlapping jurisdiction, but I'm going to leave that aside for the moment. They say what they've done is they've incorporated the means or measures to deal with greenhouse gas emission, or a mean or a measure, into the pith and substance. And then they say, that is the matter of national concern. But think about it. What's the matter of national concern now? They say the matter of national concern, as they've defined it, is their chosen means. Now, this is where I said before, when pressed about what the national concern is, BC goes back to, well, it's climate change, it's greenhouse gas emissions. But no, that just proves the point that what you're saying here, by adopting a particular means, doesn't get you where you want to go. Because, think about that for a moment. Now they're saying the means is of national importance. The means meets that first step, national importance. But there's dispute about the means. They haven't proven on the record that this is even the best, let alone only way to deal with it. Ontario says we achieved far more with what we did. Manitoba, as we say, says we've got effective ways of dealing with it. Saskatchewan says that. Alberta says that. So what they've done now by collapsing the means into the pith and substance, what they've done is they now have to justify how those means are of national importance. And they can't do that. The record doesn't show that. And think of the inquiry. Once you get into that, and I'll go back to anti-inflation, and it really touches upon a point that my friend from Canada said yesterday. In anti-inflation, remember the debate between Justice Betts and the majority over how much evidence you needed to prove an emergency. And the majority said, well, look, and really, I don't know if they use these terms, the same terms as my friend, but if there's a rational basis for thinking that, we're going to accept it. Justice Betts says, that's not good enough. When you're taking over this power, even temporarily, you got to do more than simply have a rational basis. But that debate was won by the majority. And we know that with an emergency, which is only temporary, a temporary taking of the power away from the provinces, yeah, maybe that's fair enough. A rational basis is sufficient. But is a rational basis simply because we think this is the best way to go, and we've got some experts, and there's lots of experts that say it's the most efficient way of doing it. But the new ECHO fiscal report that we put in our supplementary brief, I don't know if you had a chance to look at it, they said there are three ways, these three ways of doing it, two of which don't involve carbon pricing. Now, it may be more costly, there may be other things, but that's not to say that the carbon pricing mechanism, as BC has incorporated it into its pith and substance analysis, is a matter of national concern, that you can say it is so important to have carbon pricing over any other method that it's now become a national concern. So you can see that BC's attempt to narrow it runs afoul of the first step in the national concern analysis. Is this a matter of national importance? Carbon pricing? That's just your policy means. It's not ours. And there are others that can achieve the same objective. But here's, and this is what I think is significant. When BC was pressed on this, and they started talking about what the matter of national importance is, it came back to the global climate change. You know, they couldn't say, well, the matter of national importance is the Canada's carbon pricing scheme. It goes back to greenhouse gas emissions, effect on the climate, effect on the environment. And so they're right back, even though they've attempted to narrow it much more than Canada, which, as I said before, adding minimum standards doesn't get you out from under the fact that this is just about regulating greenhouse gas emissions and all of the pervasive and invasive aspects of that. When BC is pressed, it comes back to that same point. It's greenhouse gas emissions. Professor Adoran and all the interveners, it's all about greenhouse gas emissions. And so BC's attempt to narrow it in a way that gets over the problem of the pervasiveness of dealing with greenhouse gas emissions doesn't work. They're forced to come right back to the beginning. It's all about greenhouse gas emissions. Okay, I want to move from there to just make one other comment, because I jumped ahead a little bit with the exclusivity and the overlapping and concurrent. And I just wanted, and you probably had a chance to review it, so I don't want to belabor it, but we included in our supplementary book of authorities Professor Dwight Newman's article. Did you have a chance to look at that? And, you know, he says, in essence, exactly what I've been saying. And this is in our supplemental book at tab 40.
Is this the article that just came out in the Saskatchewan Law Review?
Yes. And again, I don't want to spend more time than's necessary. You know, I could read the passages, but maybe I'll just take you to them, just give you the page numbers. Under the heading subsidiarity in POG analysis, I would commend reading the next couple of pages, which makes the point about exclusivity that I've just been talking about. But then again, on page 199, he makes the point, and we've touched upon this before, he makes the point that, look, if we open the door here to getting around this by calling them minimum standards, how do we ever close that door? What does that amount to? And we had quoted in our reply factum and included, where is it here? John Leclerc's, we actually cite, and this, again, you don't have to turn to it, paragraph 41 of our reply factum, Jean Leclerc's point, which is essentially, he wasn't talking about, you know, the breadth of once you add national standards, how far you can go. He was just talking about in this area, once you open this door, it's this pricing scheme today, it's some other scheme tomorrow. That's Jean Leclerc. So anyway, that's those are my comments about subject matter and exclusivity. I just want to make one brief point, and this is because this was, you recall, you questioned Mr. Morley about this. Well, isn't this open the door to other things? And he said, well, maybe not. But in each case, you have to do a proportionate balancing. And remember, going back to Crown-Zellerbach, it was easy. The predominant effects, as Justice Ledane said, were extra-provincial. That was easy. But now it's not so easy. It is, okay, and you have to also take into account the means being used. It's not just the subject matter. Okay, now you have to weigh, let's take greenhouse gas emissions, or even carbon pricing, or any other matter. You have to weigh, okay, what's the effect extra-provincially? And Chief Justice Richards, in paragraph 155 of his judgment, talks about the effects. And if you read that, I think he probably overly minimized them, but leave that aside for the moment. And by the way, carbon leakage, we've included at tabs 13 and 14 of our condensed book, and again, I won't take you to them, the expert report of Nicholas Rivers and another eco-fiscal report. Both of them talk about carbon leakage and talk about the same thing that Chief Justice Richards talked about, that carbon leakage is only really going to be a factor in a few sectors. But they go further and say you can deal with carbon leakage through the design of your regulatory system. So I commend that. But leave all of that aside. The only point I want to make now is this point about proportionate balancing and what that means for the courts in these cases. That, and again, it's all tied into the various policy measures that are being adopted or could be adopted. And the court's now going to have to decide in each and every case, well, are the effects more on the extra-provincial side or the intra-provincial side. And I don't think that that is the type of inquiry, and I say this with the greatest respect, that the courts are well suited to engage in, particularly when what turns on it is which level of government is going to have the power to do this, and specifically, is the federal government going to have the exclusive power to deal with this, with the provinces at the margins.
It was argued yesterday, you've heard all the arguments, more than one, well, one party in particular has argued that the effect on the development of natural resources in Alberta and Saskatchewan would be minimal. And I believe it was argued, and I just want to lay out
And
what
we are
the
going to
arguments
deal
were.
with it. Mr.
0.01%, okay? That's
Mr. Delansky is going to clarify that, and the greatest respect to my friend, Mr. Marco, inaccuracy in her reading of the transcript of Mr. Savage's, but we're going to come to that.
Okay, that's, I wasn't dealing with Mr. Marco at that point because it has been argued. I think Canada said that it is a minimal effect on the on the Section 92A because the evidence on the record is limited in terms of what the potential impact would be, at least of the carbon pricing as of today. And then, yes, Mr. Marco went further and argued that it would not only not be neutral or a minimal impact, it would be actually a benefit to the development of resources. I hope I've captured that sense.
Yes, and we're going to deal with that, and we're going to show.
But you need to discuss, therefore, before we hear from your colleague, why that, apart from the factual part, why those propositions are or are not correct in law in a division of powers case.
And I think you just emphasized my point. In a division of powers case, particularly under the residual power. And remember, we're not talking about express powers. We're not talking about express powers where maybe these type of impacts maybe can get. We're talking about the residual power. And the residual power does not turn. Adding this power to the federal list does not turn on the effects on the province at any one particular point in time, or the effects on the extra-provincial effects based on the policy measure adopted by the federal government at any particular point in time. What this does, and that's why I like that article of Brian Schwartz's so much, because he shows Manitoba has its own way of dealing with it. Now, I don't know the effects of carbon pricing in Manitoba, but Manitoba believes that its method of dealing with it is at least as effective, but it also is going to be better suited for the circumstances of Manitoba. Premier Moe said the same thing in Saskatchewan. So I don't think that this type of proportionate balancing has any role to play, should have any role to play in this constitutional analysis under whether this is a power that should be added permanently and exclusively to the federal government, that it should turn on the proportionate balancing at any particular point in time.
And what does it turn on?
Well, it turns on what I said before. You've got to, first of all, identify this matter of national importance.
No, I'm not talking about that. I'm talking about the third part of the test, the part about whether this is reconcilable with areas of provincial jurisdiction. How do we assess that?
Well, reconcilable. When you are, and first of all, you'd look at, okay, what power are we giving, this is just like Justice Betts, what power is the federal government taking over? How pervasive is it? It's not salt water and dumping pollutants in salt water. It's across the board in terms of activities within the province. So we see that pervasive scope, and then we see how invasive it is in terms of tying the hands of the provinces in terms of adopting their own policy measures to deal with this matter. And I think I don't think it's something that's capable of, okay, we're gonna, read months and months of evidence about each industry. I think it comes down as simply as Justice Betts put it. How pervasive is the impact on provincial jurisdiction in terms of the activities?
Well, how pervasive is it? What's Alberta's position? How many sectors are affected? Is it something that's substantially impacting on the ability to develop the resources? Where is the lion's share of the money recovered coming from? All of these issues are relevant.
With respect, I don't think they are. Here's how pervasive it is. It cuts across all activities within provincial jurisdiction, all intra-provincial activities. That's the pervasiveness. So, yes, and what we know is today it's a carbon price at a certain amount. With respect to certain industries, we don't know what it's going to be like in the future. And also what we don't know, once we've given exclusive jurisdiction, how this will morph into something more significant.
How do you say that it cuts across all activities when it has been suggested it's restricted only to certain offensive greenhouse gas emissions in certain identified areas?
Well, it's consumers who are buying fuel are paying that levy each and every time. So obviously it affects that activity, and it's supposed to affect that activity. It wants to change their behavior. And actually this is probably a good jumping off point to talking about getting the money back. Right now, under Part 1, and this is at the discretion of the federal government, it's 90-10, it's a tax credit, 10 is like a slush fund we give out, but it doesn't always have to be 90-10. It could be whatever they want. It just has to come back, and that's at discretion of the provinces. And under Part 2, the output-based pricing, the industrial emitters, the large ones, they don't even have yet the rebate formula or system. And again, that would be variable. So yes, it is both pervasive and it at least is, well, I shouldn't say at least because inflation cut across a lot of areas and the regulation of inflation or matters relating to inflation was very pervasive. But this is equally as pervasive. And you can see in anti-inflation, Justice Betts didn't go, okay, show me how it's going to affect you now. He said, no, look at the broad swath that this cuts. And then the invasive part. I just want to emphasize the invasive. Look at Manitoba. They say, no, we want to do it this way. And it's at least as effective in our view. Ontario, you heard them saying, we've reduced emissions more than anybody else and we get no credit for it. No credit. Saskatchewan says, so it's both pervasive and invasive. There's no way that you can fit this within, and somebody said yesterday, Crown-Zellerbach is a high watermark in terms, and Justice Laforêt obviously said, well, he continued that theme along. I don't think it was even justified there, but think of there, where all you're talking about is giving pollutants in salt waters in a province and adding it to the federal list. How limited that impact is. And Justice Laforêt, the minority there, thought that was too far. This goes well beyond that.
Does Alberta have any concern about the fact that the federal government has set different rates for different sectors of industry as well?
Well, what it has concern about is it's at the discretion of the federal government. It sets the rates, it determines that's the loss of its control over such an essential matter. That's what concerns Alberta.
Okay, so you're saying they're not concerned about the fact that different sectors of the economy have different stringency standards they have to meet, and that there's the differential is from 80 to 95%, and certain ones are at 80 and other ones are at 95, and sometimes there's some in the province that's 80, but sometimes they're 95 as well.
That variability, I don't think there's anything in the record from Alberta saying this is problematic, that's problematic, because Alberta's point is not tied to any particular impact on any particular industry today. It's much more broadly based on the impact on provincial jurisdiction generally. And we're going to have some statistics. My friend, Mr. Delansky, is going to turn to this. He'll show you that, yes, and just to jump ahead, what Mr. Savage was talking about was not the impact under Canada's plan. It was under Alberta's plan. And now he's going to take you to some documents that show under Canada's plan, the impact both in terms of dollars and jobs.
You gave us right at the beginning of your submission a comment that you gave us a citation to a case that deals with the application of a law later on based on evidence, the applicability of a law, which I think we all understand, the concept that you can challenge it later on the applicability issue, which is essentially what Chief Justice Richards said in Saskatchewan, and you referred to that, and thank you for that. But the question I'd like,
Marco's case, not mine.
I understand that, but the point is this. Do you accept the proposition that was also put to us yesterday that you could challenge the constitutionality later based on if the effects turned out to be worse? In other words, once this court makes a decision on this issue, or the Supreme Court of Canada on the constitutionality of the legislation, is it your understanding, not on applicability to a given entity, is it your understanding, is there any law that says you can come back 2 or 3 years later and then argue that it's unconstitutional because it has now, in effect, turned on and affected the core of the province's jurisdiction?
My answer is no. And the reason why it's no is because in all of the other cases under the residual power, it was given permanently to the federal government, doesn't fall within provincial powers anymore, and none of those cases turned on the impact on the provinces such that the court wrote a decision that said, okay, based on these facts, it's only going to count, it's going to cost you this much and this much. But, which leaves open, and that's the problem. Any decision in this area that's based on, okay, we're going to look at this act and we're going to determine what its impact is, and we're going to write, well, even though you don't have the evidence to do that, but even assuming you did have the evidence, that you went through that type of evidentiary inquiry and said, then yes, I guess if that's the basis of the constitutional decision, and certainly there's no precedent for that under the POG power, but if that's the basis, yes, every province will look, okay, we got new evidence now. We're going to come and we're going to challenge it now all again with our new evidence. And that is such an unstable foundation for our constitutional system. And again, as I said before, I don't think the courts are capable. I'm not saying you're very capable, you can do lots of things, but I don't think you would want to get into that type of fact-finding inquiry into determining who is going to have power, whether the federal government's going to have this exclusive power, which, by the way, wouldn't be permanent anymore. It would be dependent upon a certain factual situation.
If we were to accept the characterization and proposition that has been advanced by Canada on the constitutionality of the legislation, and in particular that its pith and substance, the matter was establishing minimum national standards that are integral to reducing nationwide greenhouse gas emissions, would that allow Canada to do more than simply set minimum standards on pricing? Would it allow them to set minimum standards for emissions on both existing and new projects?
See, that's what Canada says. That's the way how they've defined the subject matter matter of national concern. It is the setting of national standards. They don't tie that to the pricing. It's only, and let me go back and go through this with you again. They don't tie that to the pricing. What they say is, then we have this act. They say, first of all, here's the matter of national concern. It's the establishment of minimum national standards that are integral to reducing nationwide emissions. No mention of pricing, no mention of a particular means. It's just tacking on this minimum or national as if somehow that gives them the right to take over provincial power, and it doesn't. It doesn't. And so with the way Canada frames it, it's all about greenhouse gas emissions, and it's all about the concern generally to do whatever's necessary to deal with it. Then they say that the means we've chosen is this carbon pricing scheme, stringency, whatever. That's the means to achieve what they say is the matter of national importance, the pith and substance of the act. So Canada's defined it in a way that leaves them broad discretion. And this type of broad discretion over this pervasive array of provincial activities that the Chief Justice in Saskatchewan and the majority in Ontario said, no, that's just too much. Just too much. So Canada hasn't in any way, they've reformulated their approach, but it's the same as before. It gives them jurisdiction generally over greenhouse gas emissions.
And it has been suggested on the greenhouse gas emissions that this is perhaps not that pervasive because there's much that we do that wouldn't be in the prohibited category, if I may put it that way, the ones that have been classified as really bad, let's say. So, well, that was the suggestion that was made, I believe, one of the recent interveners was to the effect that those are just those ones, they're in the new category and they're particularly bad, and you can't confuse from the point of view of the environment and scientific evidence, mix up the ones that would be not in and as egregious a category as the ones that are listed.
There's listing of fuels, and there's a levy on the purchase of fuels by consumers. Well, a levy on the seller that's passed on, the cost is passed on to consumers. And then you've got the large emitters, and yes, there's some industries are not on now, they may be later. But to say that that's not pervasive, really, you're really, much like in the anti-inflation, you're cutting across most activities within the province, purchasing fuel, emitting greenhouse gas emissions in some way. Of course it's pervasive. It's not like saltwater pollution. My lady, I was going to turn it over to my colleague now to deal with some brief evidentiary matters.
All right, and thank you so much, Mr. Gall. Any questions that the panel has? Thank you.
Good afternoon, Chief Justice and Justices. I recognize I'm standing between everyone and flights to less beautiful places in our great country, and between you and your deliberations. So I will try to be brief. I have 3 points that I wish to address in reply. The first is a comment that was made by Professor Adoran about, with reference to the cross-examination of Alberta's affiant Bob Savage, whereby Professor Adoran highlighted that Mr. Savage admitted that Alberta currently doesn't have a plan or modeling to meet existing targets. The evidence clearly establishes that it's possible to meet the target without a federal pricing plan, that the provinces could do this. There's no requirement for the federal government's intervention, nor is there a requirement for a federal or for a pricing plan at all. Canada itself admits that the GGPPA is not sufficient to meet the 30% target. And Mr. Savage's evidence is that Alberta is constantly augmenting its policies, working to improve its policies. And so just because we aren't there today, we aren't there with our current set of plans and policies, doesn't mean that we can't meet the target in 2030. And I'd like to take you to the specific quote that was referenced, and that's at page 70, line 21 of the cross-examination. And I'll just read it briefly.
I'm sorry, did you hand up this is the affidavit that we just received here?
I'm not actually referencing those papers for this point. I'll be using those for a later point.
Okay.
But the point with Mr. Savage, the question that was asked to him was, are you aware of any policies contemplated by the Alberta government that would get Alberta to 162 megatons in 2030? 162 megatons would be the 30% reduction on our current emissions. And Mr. Savage says in response, to date, we have not come up with policies that would get us there, but I would argue that no policies could get Alberta or Canada to our targets at this point. And I would also suggest to you that relative to every time we've come out with a new strategy and implemented some new policies and evaluated those for effect, we've constantly been tweaking or augmenting our policy efforts. So I would argue that it's not a final story here. I would argue that we have a new government in place, and we were in the process of revisiting some of our policies, and we're almost about to launch a new strategy and go out and engage with Albertans on the new strategy. So I don't have a line of sight to what new policies are coming up or coming down that pathway, but we're at the front end of the process. The point being that while we're not there today, that doesn't mean we won't get there. The next point that I want to respond to is the comments that were made by my friend with the International Emissions Trading Association and a number of the questions from the court about the impact on Alberta of the federal backstop. And Mr. Gall has commented on our view as to whether or not these economic impacts are relevant to the constitutional analysis, but we want to provide the full record for the court in any event. The economic modeling that was referenced by Mr. Savage and that was commented on by my friend Ms. DeMarco was entered as Exhibit 2 during his cross-examination. And I've provided you with pages 5 and 6 of that exhibit, which is the modeling that was in question. And this was used by my friend to suggest that there would be no negative impact of the federal backstop in the event it were implemented in Alberta. And what was being referenced is on the first page of this exhibit, the third chart there. And the third chart shows a number of things, but the second line down, it indicates that the impact on the oil and gas sector would lead to a negative number, meaning a positive growth. But the chart itself is referencing a comparison between Alberta's climate leadership plan without the carbon levy, as opposed to Alberta's climate leadership plan with a carbon levy. And so it had actually nothing to do with the federal backstop. And there is a reason why the carbon levy actually had or could have had a positive impact on that sector, because that specific policy included it included a small uplift in oil and gas activity that was expected because of exemptions that were provided to that sector under that specific plan in Alberta for the first few years until 2022. The oil and gas sector would be able to sell offsets, and so that's what was being captured here. It's the Alberta carbon levy that's being analyzed, not the federal backstop. If you flip to the next page of this document that I've handed up, however, here you see Alberta's modeling of the federal backstop. And admittedly, the formatting is very bad, and don't worry about that because I'm going to take you to the more recent report of the Alberta government that actually reproduces this in a more legible form. But I'm just showing you that at the time that Mr. Savage was cross-examined, the best modeling the Alberta government had was produced, and it indicates that the impact of the federal backstop
on the total economy would have been $2.7 billion a year in 2020, $3.3 billion a year in 2025, and $3.1 billion a year in 2030. There's also a negative impact on the oil and gas sector of $1.2 billion in 2020, $0.5 billion in 2025, and $0.1 billion in 2030.
I thought you said that these numbers, the negatives, were really positives.
Different formatting, I apologize. So the first, and perhaps
So the
I should
first
make that
page, the
clear.
negative is a positive, and the second page, the negative is a
The
negative.
negative is a negative, you got it. So, and that's because we're talking about growth as opposed to actual impact on the economy. But let me take you now to the other document, which really puts this,
Just 1 second, I
Puts
want
this
to
more
write this down, that the negatives are positive, because this is dealing with growth on this one. And on the second page, the negative is a negative, because that's dealing with the effect on the economy, did you say? Sorry, the second
so
page.
the second page is the impact of the federal backstop as opposed to the 2015 climate policies of Alberta.
No, but this negative is a negative because it's
And the
not dealing with
negative
growth. It's,
represents a decrease in gross domestic product as a result of the impact of the federal backstop if it were imposed, as opposed to the projections for growth under the 2015 Alberta climate policies. Which, and the reason that we're comparing to the 2015 Alberta climate policies,
This is not in the record.
we're referencing, we're not even on that yet.
This is not.
No, we've provided it here today.
Okay, but
sorry, is this in the record? I think she's saying, is this in the
this is
record?
new evidence. That is
The-
not in the record, and it's unlike the, not that, sorry.
Oh,
the next one.
okay. So these two, are these two pages in the record? Okay.
Yeah, so I'll explain this a little bit further, and then I can indicate, and the court can decide whether or not they want
And
to.
sorry, and it was the decrease in growth in the domestic, gross domestic product compared to the 2015, did you say, Alberta
Right,
climate
the
plan?
2015 Alberta climate policies, which most accurately reflects where they sat at the time, because the 2015 Alberta climate policies would have been before the imposition of the Alberta carbon tax. And at this point, the new government had been elected and had repealed the former government's carbon tax. So this is looking at from where they were sitting at the time. If the federal backstop was imposed, what would the impact be on Alberta's economy? And the conclusion that was drawn, as you can see on the second page of the exhibit, is that it would have a negative impact, or would have a negative impact on annual gross domestic product of $2.7 billion in the year 2020 annually, and of $3.3 billion a year in 2025, and so on. Now, we've also
discussed in the
Yes.
record, is the cross-examination or the affidavit discuss this? Can we read this by looking at the material?
This is in the record. So this was produced during the cross-examination of Mr. Savage.
But is it clear?
Where is it so we can see that?
It's Exhibit 2 at page 5 and 6.
Thank you.
Okay. Now, my friends yesterday had passed up some additional information in order to aid the court. That's what we've done here as well with respect to.
I do object to this because this is not in the record. We handed us information that was from Alberta's own from Alberta's website that related to specifically the tier program, just to correct some information.
Right.
This doesn't even cover the situation. These are all models that were published November 15th, and which don't even model what is the actual situation in Alberta, which is tier and the federal backstops. I don't know how this is either relevant and or why Alberta could not have provided it to us long before today.
So, just if I may respond to that, my lady. This is a document that was produced in November 2019. It formalizes the analysis, the modeling that was that accompanied Mr. Savage's cross-examination. in the same fashion as how my friend used a publication of the government of Alberta to describe the tier program, we're seeking to use this document to help provide the court with a better understanding of the economic impacts of the imposition of a federal backstop.
Are you saying that this document purports to summarize or place in a chart form the essence of Mr. Savage's evidence? Or are you saying that this is something that his evidence was the foundational basis and additional information has been added to it to produce this?
So this certainly, this supplements Mr. Savage's evidence. So Mr. Savage used the modeling that was available at the time. The government was undergoing an analysis of the previous climate leadership program, the impact that that would have on the economy, and of the federal backstop, which is the matter before you, in order to determine the economic impact and the impact on Albertans that the federal backstop would have. And this is the document that summarizes that. And the reason that it's not in the record is because, as you've heard from Mr. Gall, we didn't expect there would be as much interest from the panel and from our friends on the real impacts on Albertans. This is the best document to summarize that, and we think it's properly put before the panel for consideration.
Have you raised this earlier with your friend and provided her a copy, or with anyone else?
Just now. We literally put this together last night, and so we gave it to her earlier today.
Mm-hmm.
Well, it seems to me, it strikes me anyway, just speaking for myself, this is a demonstration of why snapshots of life in the world at any given time aren't very helpful in legal debates.
That's right.
Just 1 second.
Right, because we've imposed here. I understand. Yeah.
I take it that Canada objects to our reviewing that, does it?
Well, we object to the way it was presented to us just after the lunch break. And we do think it's definitely different than Canada using one of Alberta's documents to respond to something Alberta submitted about their own program, as opposed to Alberta handing up one of its own documents that was available apparently about a month ago. The key point about this, though, and my friend has assured me that he would make that point, is that none of the scenarios, impact scenarios modeled in here are actually what is occurring, because it doesn't model the application of Part 1 of the Greenhouse Gas Pollution Pricing Act, the fuel levy, and Alberta's tier program. It's modeling something that doesn't exist in the province.
Yeah. And I will explain very clearly what this is modeling. This is modeling, absent the Alberta government, the recent agreement between Alberta and Canada to have the tier program.
So the figures wouldn't necessarily be that helpful to us anyway.
No, they are helpful. They're very helpful because they show you exactly what the impact of the imposition of the federal act would be on Alberta if it weren't for tier. Exactly. So if tomorrow the government of Canada chose not to recognize tier, this gives you a sense of what that means in real terms: jobs, costs to the household, and economic growth. And it's posted on the government of Alberta's website for the public's review.
Just want to clarify, is this a concern to Canada, that we not look at this? If it is, then we will not. If you say that you have no objections, we'll put it here for whatever limited use it may be, and it sounds as if it's not much.
Well, so, I mean, it's a concern to Canada that we haven't had a chance to actually say anything about it, which we might have done. I mean, if the court takes it in, it would be subject to the court's view of its weight, given that Canada has not had any opportunity to comment on it.
All right.
All right.
Yeah, yeah.
Yeah, I know.
All right, well, thank you for putting this together. I think we're all agreed that in the circumstances that we will not admit this into the record at this late stage.
Okay.
So, thank you.
Yeah,
for
and that's fine. Thank you, my lady. We just thought it might have been helpful. The modeling that is in the record does paint the picture for you to give you some indication as to the impact, at least on GDP. So you do have that to rely upon for your deliberations. That brings me to my third and final point, which is the order of events. For this, we have reproduced a portion of the Bob Savage affidavit, and I passed it up to you. We've reproduced paragraphs 237 to 276 of the Savage affidavit in order to clarify for the court the order of events, which we would submit were incorrectly, perhaps inadvertently described by Canada in their submissions. But we feel it left the court with the impression that Canada had really exhausted its efforts to try to get the provinces on board, to herd the cats, as it were, and we're left with no choice but to impose the federal backstop. And that's not what the record shows, my lady, and so I just want to walk you briefly through the timeline. The Vancouver Declaration was agreed to by First Ministers on March 3rd, 2016. That's described in paragraphs 240 to 242 of the Savage affidavit. And it's important to remember that the Vancouver Declaration recognized the role of the federal government as, it described the role of the federal government as complementing and supporting the actions of the provinces, not supplanting it. Working groups were then established and conducted their work from April 2016 until August of 2016. And they produced a suite of policy options for the consideration of the group. And those working group reports and their activities are described at paragraphs 243 to 249 of the Savage affidavit. Now, after the working groups had submitted their final reports, and without consultation with the provinces, Canada tabled the backstop on October the 3rd, 2016. This was before the Pan-Canadian framework was agreed to. And this is from the Savage affidavit at paragraphs 250 to 256. Canada's unilateral action came as a shock to the provincial and territorial ministers, who were scheduled to meet with the federal minister for further policy discussions that day, October 3rd, 2016. Several ministers walked out of that meeting, and we include a CBC News article, which includes a quote that I think summarizes how the provinces felt they were, or some of the provinces felt they were being treated on October 3rd. And this is at page A2892 of the record, and it's from Brad Wall. And he says, "The level of disrespect shown by the Prime Minister and his government today is stunning. This is a betrayal of the statements made by the Prime Minister in Vancouver this March." So clearly, when the backstop was tabled...
Sorry, please give me the citation again to that.
Sure, it's page A2892, a CBC News article quoting the then Premier of Saskatchewan. And that was October 2016. So the Pan-Canadian Framework was announced in December 2016, and Manitoba and Saskatchewan did not sign on to the Pan-Canadian Framework at the time. Manitoba specifically joined later and then withdrew again. Ontario withdrew in June of 2018, and Alberta withdrew in August of 2018. And this is all detailed with respect to the Pan-Canadian Framework at paragraphs 257 to 265 of the Savage Affidavit. So we submit that the evidence clearly shows that the backstop in the GGPPA that followed was not the product of cooperative federalism, but rather quite the opposite. Canada's characterization of its efforts to work with the provinces does not accurately reflect what actually occurred. So I hope that that sets the record straight on that point as well. And subject to any further questions, and recognizing the time of day, those are all my submissions.
Thank you so much. Does anyone have any further questions?
Thank you.
And thank you. Ladies and gentlemen, Council, thank you very much for your group efforts to provide us with all the information we need in order to assess this properly. And we're very grateful to every one of you for the time and effort you put into both the written submissions and also the oral submissions. Needless to say, we will not be delivering any decision today. So thank you so much for your attendance here today. And for those of you who are here from out of town, safe journey home. And we will obviously be issuing our decision in this matter as soon as we're able to do so. But it will not be in the next couple of days. Thank you very much.
Order in court.